record is adequately developed on things like strategic decisions made by trial counsel. Is there a reason that we don't at least have an affidavit from trial counsel?
Well, Your Honor, it's a very good point. I will be brutally honest. Trial counsel is 83 years of age. I had very difficult time obtaining all the records from trial counsel. And because it was past complaints with the Board of Bar Overseers, any type of affidavit admitting some type of fault or substandard care that he provided would probably cause him to lose his license. So there's no affidavit. The only thing I will mention, Your Honor, and again, the motion to continue the trial, okay, is signed by trial counsel as an affidavit, and that indicates he wasn't prepared on May 15, 2019, just before the trial was to begin. So I think that is substantial evidence, and that's part of the appendix, that shows that the trial counsel was not prepared and was ineffective when they started the trial.
But Judge Miller saw the trial, and she saw this defense attorney and how he conducted himself throughout the trial. So when she denied the motion for stay, shouldn't we defer to her view on trial counsel's conduct of the trial?
Well, that's a good point. The Judge Miller pointedly, it's in my brief and it's in the transcript, asked trial counsel, do you have experience in this type of cases? He said no. There was a colloquy between the trial counsel and Judge Miller regarding a case, and he was presenting evidence that was supporting the Commonwealth. So this was a travesty of errors. It wasn't a comedy because my client's been convicted and is spending time in jail right now. He's at MCHUGH Concord because of ineffective assistance of counsel.
But that case that trial counsel gave to the citation to Judge Miller was Commonwealth v. St. Louis, and that's about the definition of an intellectual disability. And Judge Miller ultimately directed the Commonwealth out on that charge. So how is the defendant prejudiced?
That's one charge, Your Honor. Okay, one charge. There was no preparation regarding the cross-examination of the victim. There was the trial counsel.
Can I ask you about the cross-examination of the victim?
Yes.
One of the things you mentioned in your brief is that you have a medical record that has some where she denies being abused by your client. And you say in your brief that you'd be happy to share that with us, but it's sensitive and in camera. So that's not part of the record at all for the trial, is it?
No, I don't believe so.
So, I mean, this is why generally you need to file a motion for new trial. At a motion for new trial, you can put in things like that record that counsel failed. We can't consider that on this appeal.
Your Honor, I would ask you to consider the motions filed, okay, by trial counsel. He asked for money for an expert on autism and bipolar, okay? The motion was allowed. This is in August of 2018, okay? So he gets that motion. He knows that he has to cross-examine the defendant. He knows he has to set up a defense to these horrific charges, okay? He knows there's going to be a biracial couple in front of a jury in Suffolk County. He should know that Suffolk County jury trials are far and few to become available, and you're not going to be able to continue the case 5 minutes before the trial starts. He does nothing. He does nothing. He does not hire an expert.
How do we know that? Where in the record how do we know that he didn't hire an expert?
The motion to continue the trial seeks that, which is part of the record in the appendix, okay, May 15, 2019. He wants the court additional time to seek the complainant's psychiatric records regarding her seizures, and he's looking to find some exculpatory evidence. If he had an expert, he'd be able to use the medical records and ask the expert, not unlike a medical malpractice claim, to develop a defense. There was no defense. Your Honor, also, he tells the jury in the opening, okay, every trial lawyer knows, every trial lawyer is told when they start, never tell a jury you're going to provide either a witness or some evidence or a statement or a recording and then back out. You lose credibility. He tells them about some bias with the victim's mother. He tells them about some, attack the credibility, and he never provides it. Again, this is substandard care. It falls below the level of a fallible lawyer. And under the Safarin and under the Strickland standard, there is a cause and effect, okay? It's just not missing one objection. It's a cumulative effect, okay? It's a trial. The Commonwealth of Massachusetts has the district attorney, a second seat district attorney. It has the victim witness advocate. It has investigators, has the Boston police, all against ROMEO THERMIDOR. And he has a bar advocate that's not familiar, who admits he's inexperienced when it comes to Suffolk County Superior Court trials, admits that this is a very complex matter, and is not prepared to go forward. He has zero defense. My clients led to an easy guilty finding and a sentence.
What do you say about the fact that prior to trial, Judge Miller heard from both lawyers about this information about a defamation suit brought by the defendant in New Hampshire against the victim's mother, and Judge Miller said, well, if the defense wants to get into that, then I'm going to let the prosecution get into the fact that it was dismissed, and the timing of it came after these allegations had been made. And there may be, and she said something like, query how helpful that is to either side, but I'm not the advocate. So apparently defense counsel made a tactical decision not to bring that up because it might hurt him.
Well, that decision should have made, Your Honor, before he told the jury there's going to be bias. So once he tells the jury there's going to be bias and he's got evidence, now he lost the jury on the credibility issue. Number two, if he wanted to bring that up, there were better ways to do it. He had the case for a year and a half. Your Honor, the reason I am being so adamant and animated regarding this issue is because, again, you have a system where he's appointed, okay? The Commonwealth allows him to get funds for expert witnesses, to get investigators, and be prepared, okay? Jury trials are physically, emotionally, and cognitively challenging for defense lawyers. We're up against it, okay? Anybody that's trying a case and defending the case in Superior Court knows that. You've got the power of the Commonwealth, you've got the victim, the victim's family, all present, you've got the advocates, and you're only sitting there by yourself, okay? It is extremely important to be prepared. We are alleging that trial counsel ineffectively assisted the defendant, was not properly prepared, and the cumulative effect, which is in my brief, which is in the transcript, okay? When a judge asks you, Your Honors, that if you have any experience in this case, this is not a small claim. This is not a district court misdemeanor.
Mr. Francesi, let me interrupt again with a question, please. Typically, the trial judge is in the best position to review claims of ineffective assistance, and yet you're asking that we remand the case and that we order a new judge to be assigned to the matter. It's not clear to me why we should do that.
That's one of my, requests for relief. Obviously, we're looking for a new trial, or if the case is remanded back for further proceedings in front of Judge Miller. We need to, like I said, my client needs to have an opportunity to be defended properly, have his defenses put forward in front of a jury, and have a fair trial.
But why wouldn't Judge Miller be in the best position to assess that?
If that's the court wants to send the case back to Judge Miller for further proceedings, defer to the judge's, the court's opinion on that.
Can I ask you about your second claim about Judge Miller denying the motion for a stay? Did you renew the motion for a stay with the single justice of the appeals court?
No.
Okay. I'm not sure if you actually can appeal a judge's denial of a stay, a trial court's denial of a stay. I think the proper procedure is to come to the court where the appeal is pending and ask for the single justice there to stay the case, and then you can appeal that.
Well, again, Your Honor, the main part of my argument in my brief, and again, I think if you look under the standard, the defendant has the burden, and I think the defendant has met his burden to show that there's been a travesty, okay? I think under Safarin, Judge Kaplan talks about a mockery of a trial, okay? He did not have the ability to have a proper defense. And we cannot, and the courts have said this, whether it's a private counsel or whether it's court appointed, it's the same standard. We as attorneys, defense counsel, should hold ourselves at a high level of responsibility, right? We don't want to devolve into the medical field where there's malpractice claims and we're all hiding behind experts, okay? We have motions that were filed that allow him access to funds. There was no expert ever brought up, okay? We have a motion to continue. I think that is dispositive. When you're in Superior Court and they're about to start a jury trial, they're about to impanel, and you walk up in front of a judge and say, I'm not ready. What other evidence you need to show that this is ineffective assistance of counsel? At that time, he should have either withdrawn his counsel or Judge Miller should have taken on her own sua sponte to have the case continued and have another attorney appointed. Thank you.
Thank you, Attorney Francesi. I neglected to call the case at the beginning. Just for the record, this is Commonwealth versus Romeo Thermidor 2019 P 1630. I'm sorry about that, but it's now on the archive tape, and we'll hear from you, ADA Kesselheim.
Good morning, Your Honors. May it please the court. Assistant District Attorney Dara Kesselheim on behalf of the Commonwealth. And I would also like to acknowledge the presence of Assistant District Attorney Michael Glennon, the trial prosecutor in this matter, who is participating by live stream. The Commonwealth respectfully requests that this court affirm the defendant's convictions where there is nothing in the record before this court to show that the defendant's trial attorney his performance was substandard or that the defendant was prejudiced by his attorney's conduct, and where the judge accordingly did not abuse her discretion in denying the defendant's motion for a stay. First, I would point the court to initial comments made by Justice Kinder regarding what is before the court and what's not before the court. There was no motion for a new trial filed in this case. So this court's inquiry is limited to the trial record. Under Commonwealth versus Diaz, 448 Mass 286 at 289, it's a 2007 case. This court made clear that the factual basis for an ineffectiveness claim has to be indisputably in the trial record in order for this court to review a claim on appeal with where no motion for a new trial was filed. And simply put, that's not the case in this matter. The first claim that my brother brings is that his attorney failed to hire, it was ineffective for failing to hire a private investigator or retain certain experts. And there is simply no basis in the trial record to conclude that this is the case. As my brother mentioned, his attorney, Attorney Abelo, did file motions for funds for both an investigator and an expert on bipolar conditions and an autism expert. All three of those motions were allowed. So nearly a year and a half before trial, a motion for an investigator was allowed up to $1,000. Nearly 9 months before trial, motions for experts on bipolar conditions and autism were allowed up to $2,000 apiece. And there's simply no evidence that trial counsel did not use the services of an investigator or consult with experts. It is true that he did not call an expert at trial, but the
Would
trial.
there be any strategic reason for not calling an expert, assuming he had access to an expert because of the motions for funds? What strategic reason would there be for not calling one?
So the strategic reason appears in the trial record at volume 2, pages 28. Where he states that he believed it was the Commonwealth's burden to prove an intellectual disability and that he didn't have a burden to do that. Now, when we're looking at the question about whether to call an expert witness or not, that decision is, the SJC has recognized, fits squarely within the realm of strategic or tactical decisions, and thus, in order to be shown to be ineffective, must be manifestly unreasonable when made. Here, it clearly was not manifestly unreasonable for him not to call an expert on those conditions because the only charge for which the victim's intellectual disability was directly relevant was directed out. So that was count 6, and the trial counsel filed a motion for a directed verdict on that count, which was allowed. I would also note that the judge—
Well, it might have been relevant to her capacity to consent as well, right? On the other
Excuse-
charges, an expert might have given the jury some information on her intellectual ability to consent.
That I think that might be more relevant if this were a case that was more about consent. The allegations here were not were violent, forceful attacks, not according to her testimony, not sort of either she consented or she didn't consent. The question, I think, came down to credibility between who you believe. Did you believe the victim who testified extensively on 2 different days at trial, or did you believe or did the jury believe the defendant who also testified in his own defense and told a very different version of events regarding the entire status of their relationship and their sexual relationship? So I think that to answer Your Honor's question, no, I don't think it would be relevant to that issue.
My
think
understanding
also,
of defense counsel's closing was that the defense theory was that the victim had consented and then lied about consenting because her mother hated the defendant.
yes, and so that those issues of bias were also brought out during cross-examination of the victim. So and on direct examination of the defendant. So the theory of the defense was really there are 2 sides to every story. It was a consensual relationship. They had a dating relationship, and that she's not telling the truth. She's motivated by this animosity. He brought out the animosity of that the defendant felt, or the hostility the defendant felt from the victim's parents on his direct examination of the defendant, and he also tried to poke holes in the victim's testimony in his cross-examination of her, which was extensive. I would also point, Your Honor, to the fact that the defendant was acquitted on one of the counts of rape. So he was found not guilty on one of the counts of rape. And he was also found not guilty on strangulation and kidnapping. And as I mentioned before, the assault and battery on a person with an intellectual disability, he filed a motion for a required finding of not guilty on that charge, and that was allowed. So to say that this defense attorney didn't mount a defense, or that the jury wasn't able to sort of weigh the charges and the elements of the charge is not borne out by the record in this case. With respect to the second issue, the second claim relates to evidence that the defense claims that his attorney should have or could have brought out at different points. Again, we don't have an affidavit from trial counsel. We don't have an evidentiary record. It's impossible to say. It would be mere speculation to speculate as to why certain evidence came in or didn't come in, or why Attorney Abelo made certain strategic decisions in terms of the evidence he would introduce or not introduce. I would point out to the court that he still is an active member of the Massachusetts bar. He does practice regularly in the courts of Suffolk County. To say that he is inexperienced in cases in Suffolk County is incorrect. He is an active member of the Massachusetts bar who practices regularly in Suffolk County and has for years.
Wasn't the record that when they were discussing the indecent assault and battery on a person with an intellectual disability, that ADA Glennon didn't have experience trying those kind of cases either? It was kind of first for both of them.
Right. I think that's correct. And that issue of the intellectual disability prong of that charge was discussed extensively. And ultimately, the judge concluded that an intellectual disability was different than an emotional disability, and again directed the verdict on that charge, basically finding that the prosecutor hadn't proved intellectual disability, and seemingly agreeing that expert testimony would be necessary to prove the issue of intellectual disability. And I would point the court to trial transcript volume 5 at page 240, where that is discussed.
So if the defense had called an expert on intellectual disabilities, is it possible that the prosecutor on cross could have elicited information about whether or not somebody with a 139 IQ could fit within the definition of the statute of an intellectual disability?
That's possible. I'd be speculating, Your Honor, as to what the content of an expert testimony would be on that issue. What I can say is certainly the defendant wasn't prejudiced by not calling an expert on that, because the count to which that is relevant was directed out. That was filed as paper number 64. It appears in the Commonwealth Appendix at pages 29 and 30. The judge, who I think, as Justice Grant had pointed out earlier, had just observed the entire trial, had observed defense counsel's performance throughout trial. The basis of the motion for a stay was the claim of ineffectiveness, and she found that, in considering the correct metrics to be considered on a motion for a stay, she found that she did not think that there was a reasonable possibility of success on the merits based on an ineffectiveness claim. That's at volume 9, page 32. And certainly, having just observed the trial, her conclusions with regards to counsel's performance would be entitled to substantial deference by this court. Unless the court has any further questions, the Commonwealth is content to rest on its brief.
Seeing none.
We are live and on the record.
Good morning and welcome to the Massachusetts Appeals Court oral argument session for November 6, 2020. As you know, this argument is being conducted on Zoom and simultaneously live streamed on the Appeals Court YouTube channel. And nonetheless, we follow the same rules and customs as in the physical courtroom, except you don't have to stand during argument. Once we get going, the session clerk will put a clock up in the where the Appeals Court insignia is there, and it will show that you have 15 minutes to argue. Each side gets 15 minutes. There's no rebuttal in the Appeals Court. When you are not speaking, the clerk will put you on mute, but we can still see you. So please remember that, and please keep your gesticulations and reactions to a minimum. The proceeding is being recorded and will be archived and available to the public afterwards. As always, we've read your briefs and we're familiar with the case, so you can jump right into it. You're free to use all 15 minutes, but there's no penalty if you end early. So calling the case, it's Commonwealth versus Sarah SCAFURI, 19P 1578. Attorney Madison.
Good morning, and may it please the court, Nick Madison for Sarah SCAFURI. The admittedly unusual facts of this case raise a tangle of legal issues. And two things that are clear are as to the charged offense of assault and battery with a dangerous weapon. There was insufficient evidence as to intentional assault and battery with a dangerous weapon. And the facts at trial raised a significant question, at a minimum, as to causation for the alleged victim's injury in this case. And the jury was not instructed on proximate causation, which is the proper measure of causation for reckless assault and battery with a dangerous weapon. These two errors require a new trial in this case. And I would like to focus this morning on the assault and battery with a dangerous weapon charge. As I just stated, the evidence was insufficient as to the theory of intentional assault and battery. The victim was very clear in her testimony in this case that she was never struck by the car. She was asked if she even grabbed onto the car. She denied that. She testified that she only grabbed onto the passenger in this car, whereas Ms. SCAFURI was the driver in this case.
But nonetheless, doesn't Ms. SCAFURI see a person hanging onto the car and nonetheless starts the car and tries to drive away, trying to shake her off? Isn't that, that seems to me kind of an intentional battery.
I don't, respectfully, Your Honor, I don't believe that that is quite how the facts panned out in this case. But this case does, because the facts are somewhat unusual, require a close drilling down into the facts. Now, what the alleged victim testified to was that there was, at the relevant times, an argument between the passenger and the alleged victim. The alleged victim approached the side of the car. The alleged victim, quote, got in the face of the passenger. By her own testimony, went to smack the passenger. The passenger grabbed her hands. And then the victim testifies around this time, the victim testifies that Ms. SCAFURI shifts into what she hears something that she believes is the car shifting into drive. At that point, the alleged victim testifies that the passenger lets go of her as the car shifts into drive. And then the passenger grabs on to the victim, either her shirt or her hands. It's a little unclear from the victim's testimony, but grabs onto the passenger as the car shifts into drive. At this exact moment, the exact timing is a little unclear. The victim doesn't testify entirely consistently as to whether this was before the car started moving or right as the car started moving. Vilo, the alleged victim, who the alleged victim refers to as her nephew.
Mr. Madison, let me interrupt you for just a moment. We've read the sequence of events, and my question is, couldn't the jury reasonably infer from the fact that the woman was hanging on to the car, or the passenger was hanging on to her, and she was screaming through an open window as she was dragged across the parking lot? Couldn't we infer from that the driver was aware of that fact?
So, two points. One is, it's important to remember that the entire sequence of events in the parking lot and driveway happened, by the victim's own testimony, extremely quickly. She testified that it all happened very quickly. There's also a photograph in evidence that shows the entire distance traveled by the victim. And so all of this happened very fast and interrupted by the Vilo leaping up onto the car, and by the victim's testimony, pushing her into the window of the car. So as to an intentional assault and battery, the question is, did Ms. SCAFURI intend contact with a dangerous weapon?
How about as to a reckless assault and battery?
Happy to get to that. The reckless assault and battery is where we arrive at the issue of causation. Because there were three actors involved in this case, apart from Ms. SCAFURI, that played a role in her moving with the vehicle when the vehicle started moving: the alleged victim herself, the passenger, and the person known as Vilo. All of whom, the passenger by grabbing onto the victim by grabbing onto the passenger, and Vilo by leaping into the car and apparently pushing her into the car. That evidence, all of which comes from the alleged victim during her testimony in the Commonwealth's case, and is uncontradicted, only allows the inference that those three actors' conduct is the reason that she traveled with the car, and not that the car would have otherwise pulled away without her traveling with it. And so we get, we arrive at a causation.
Are you saying she's not even a but-for cause? Let's start with that.
Certainly she was an actual cause insofar as she started the car in motion. Okay. But the question is, was that a remote cause in light of the superseding events of the three other actors? And I think framed in the facts of this case, would the car have pulled away without contacting her at all and without bringing her along, without the conduct of these three other actors here?
So is your argument that in the light most favorable to the Commonwealth, if a cause is remote enough, it's not a sufficient cause to prove assault and battery dangerous weapon?
So my argument is that I believe in the MARGO case, I'm not sure if I'm pronouncing that correctly, the SJC said that proximate cause is the proper measure of causation in a assault and battery with a dangerous weapon case, and that under principles of assault and battery, principles of proximate cause as applied to a criminal case, if you have superseding causes that are not foreseeable, that breaks the cause of causation from the defendant's conduct. And if they're unforeseeable and break the chain of causation, that liability does not follow in that circumstance.
Mr. Madison, if we were to agree that the judge could have given a more elaborate instruction on causation, that brings at least me to the next question of, is there any authority requiring the judge to give such an instruction?
So I'm not aware of a case where where this court or the Supreme Judicial Court has said that a judge must give a proximate cause instruction as to this offense. Where I believe the rubber hits the road in this case is the facts clearly raised this issue of causation from the three actors' conduct other than Ms. SCAFURI. And that the charge as provided by the judge, which just say that the defendant must have caused this, the injury as to a reckless assault and battery, does not actually.
Would you agree that the charge that was given was the model charge?
It does appear that the judge's charge followed the model. My argument is that in the context of this case, in the specific facts of this case, the model was not sufficient insofar as it did not inform the jury of the relevant principles of proximate causation, which is the appropriate measure of causation in this case. And in fact, the fact that the judge limited his instruction, not through faulting the judge, because this is in fact model instruction, but as applied to this case, using the term that Ms. SCAFURI caused the injury, actually may have resulted in the jury believing that any cause, even a remote cause, even a but-for cause, was sufficient. And it creates getting to the substantial risk portion of the analysis, it creates a substantial risk that the jury actually could have found Ms. SCAFURI's conduct to be a remote cause of the injury and still convicted her on conduct that was not criminal, on principles of proximate causation. I'd like to return just quickly to if there's no other immediate questions, to the intentional assault and battery, and just note that the Commonwealth cites essentially three pieces of evidence that they say get them over the hump on intentional assault and battery. They cite a prior inconsistent statement that the defense counsel elicited from a police officer, and then two hearsay excited utterance statements.
The Commonwealth takes that position in their brief, or at least they refer to it, but isn't it accurate to say that the theory of the case was reckless assault and battery at trial?
I believe that is true. The judge said that he believed that the facts in this case suited reckless assault and battery, but that he would instruct on both. It seems clear that, and this may be because the victim's prior inconsistent statements kind of changed the context of what the Commonwealth was relying on at trial, but I believe Your Honor is correct. It appears like the Commonwealth, given the evidence that actually came out in trial, how they closed on the case, was relying on a reckless theory of intentional assault and battery. But as to their argument in their brief, none of these statements, none of these pieces of evidence get past obviously Lattimore does not set a particularly rigorous standard for the Commonwealth to get over with the light most favorable to Commonwealth, but the Commonwealth must do more than point to some evidence, however slight. They need to do more than that. And in this case, the evidence they cited, a clearly prior inconsistent statement that was entirely inconsistent with the story with the testimony that the alleged victim actually provided in this case. And
just to be clear, this is the statement that the car, that she tried to cross in front and the car went forward for. Is that what we're talking about?
The statement was that through Officer, I'm forgetting which officer it came in through, I think Officer Barrero perhaps, that Ms. SCAFURI waved her across, and then she after waving her across, drove forward and she impacted the car. Obviously, that's entirely inconsistent from her testimony at trial. It was clearly listed as a prior inconsistent statement. And given the context of the trial, I don't believe any juror would consider that substantive evidence of actually what happened. And in fact, even though there was no objection at the time, when defense counsel was cross-examining the victim in this case, he did approach the judge for guidance on how to impeach Ms. SCAFURI with this statement, and the judge set it out. If she denies the statement, then you have to call the reporting officer, and then you can impeach So the point is that everybody knew, the Commonwealth, the judge, everybody knew that this was being introduced as a prior inconsistent statement. And I would just say, as to the two hearsay statements, obviously I'm challenging one as improperly admitted excited utterance evidence. But even putting that aside, neither one allows the inference of an intentional assault and battery with a dangerous weapon. One, the statement is that the vehicle had just, quote unquote, hit the victim, and the other one was that the vehicle had just dragged the victim.
By the way, in making your argument in your brief on that point and analyzing the excited utterance, you say that there were no injuries to the nephew or to any other person. But wasn't there quite a bit of evidence regarding injury to the aunt?
Yes, there was. And actually, I took over this case from another lawyer, so I did not author the principal brief in this case. But yes, that is in the brief, and I would say Your Honor is correct. There was evidence of substantial injury to the alleged victim in this case.
On the excited utterance issue, what was the excitable event? Was it velo? Was it the victim's injury? Velo hanging onto the car for some distance, or was it velo being stopped by the police?
So I think it could be either the hanging onto the car. To be honest, I'm not challenging the. If I may continue just to answer the question briefly, I'm not challenging that an event that was sufficient to cause an excited utterance occurred. I'm challenging that there was no evidence in the record that Velo was given the testimony of the tone of his voice and the testimony of the time that passed before he made the statement after first being observed by the police officers. There's no evidence that he was still under the effect of that startling event, such that that was not the product of reflection and deliberation.
Justice Grant, any follow-up? Okay.
Thank you.
Any more questions? Thank you very much. We'll turn to ADA Payne.
Good morning.
Attorney Payne, it seems like I see you every week. Is it just me, or is this true?
It does seem to be that way lately, Your Honor. May it please the court, Assistant District Attorney Cynthia Payne for the Commonwealth. I will start with the defendant's issue 1, the excited utterance. Here, Velo's statement, he was trying to stop the van because it hit his aunt, qualified as an excited utterance. Here, the defendant has conceded that there was a startling event, but we have two, I would suggest, startling events. First, we have the fact that Velo's just witnessed the van hit his aunt. And then he instinctually, he jumps onto the van and the minivan takes off down the street and it's driving for approximately a mile, either a half mile or to a mile. I believe the police officer testified approximately 50 miles an hour. I would suggest that certainly is the second sufficiently startling event. And I would suggest that the Guaman case is certainly right on point, in which, although the declarant in that case was very calm, the trial judge noted that her concern was for someone in danger, and that's what we have here. We have Velo stating, "This car just hit my aunt." It's clearly, even though the officer testified his volume was neutral, his manner was antsy. I would suggest that the nexus between that statement and the exciting event, the proximity to both temporally and locale, certainly it qualifies. It rendered the normal thought process inoperative.
Can I ask you a question? In your brief, in this section of the brief, you reference a statement in the next day at trial that the same witness makes to a different officer that seems much more urgent. He was screaming, "I need to talk to a police officer now." How do you intend for us to consider that with respect to the other officer's testimony?
I don't think you really can, because I would admit that's sort of backdooring it. You can't really do it, because the judge had to decide with the testimony that he had before them. But I think the judge was properly, based on Ms. Rodriguez's testimony. She testified that the police had come pretty quickly. I think that what the trial judge had in front of him was enough. There was enough support in the record for him to make that call, that it was an excited utterance and it was not an abuse of discretion.
Ms. Payne, let me just ask a clarifying question on that point. Are you saying that we have to analyze the admissibility of the evidence at the time the judge made the call, even though later evidence in the trial might have supported that decision? We should not reference that?
I don't think in this instance you can. I believe there's case law that indicates if things later, strike that.
This is really just a question of admissibility, not admissibility at a particular point in the trial, correct?
Right, but the trial judge is making the point, is making the call right then. Certainly, I mean, the testimony was vastly different. We have Officer Barrero, who testifies that this individual was hanging off the door, screaming, "I need to talk to somebody." So certainly the testimony is different, but it is my understanding, and hopefully I'm wrong, that it has to be at the time. But even if it's, I think the officer who testified first, I think, again, there was enough support in the record that the judge's decision was not an abuse of discretion. If there's no questions on the confrontation clause, I will move to the assault and battery, dangerous weapon charge.
Just one more question on that.
Sure.
2 questions on that. So the first statement that comes in the first day of trial with Officer Nunez, I think, and then compared to that other one, which is Officer Barrero. The Barrero one seems to be sooner in time. It seems like that Nunez's function, he's getting everybody out of the car. He's putting, I think the testimony is he puts the Velo into his cruiser. So it is, isn't that like it's further on in time? And I mean, would that be, it's no longer a reacting to an emergency, but now we're at the evidence gathering stage?
I would still say that it's still a very quick point in time. And I think, again, I keep wanting to go back to the Guaman case, in which, although the person who had called the person who called 911 was very calm. I think the fact that there's comment and a little bit of time has gone by. I mean, it is a subsequent, but I still think that there was enough support in the record that to support the judge's decision, and it's not an abuse of discretion. And I know this court gives great deference to the trial judge's finding. And again, I think there's sufficient support in the record. Did you say you had a second?
The follow-up question was on the whether the confrontation clause was preserved or not. Clearly there's an objection to the spontaneous utterance, and the defense argument is that it's sort of understood that would also be a confrontation claim. Do you have any cases where it's been held that an objection to the spontaneous utterance part doesn't necessarily raise the confrontation part?
Oh, not at my fingertips, but I feel like I've seen something on point when I did my research. I didn't write it down, but I think it's very, actually, I think I know there is. I can't grab it for you right now. I can come up with I can certainly provide the court with a letter after argument. I know that the defendant indicated that the trial judge cut him off. Defense counsel indicated that the trial judge cut him off, but I think the record really shows that Judge Maltby was very patient, and it was clearly this was just on hearsay grounds, not on the confrontation clause. Did you have any other questions regarding the confrontation clause? Okay. In regards to the assault and battery dangerous weapon, I know certainly there was more evidence as to the reckless theory, but I did want to bring out that they're in the light most favorable to the Commonwealth. And I would dispute some of the facts that my brother has set forth. Here, it was very clear from the record that the victim had a difficult time testifying. In fact, at one point they had to take a break for her. I mean, she really was kind of all over the place. But I would suggest that in the light most favorable to the Commonwealth, a jury could have used Belo's statement. The van had hit his aunt to prove that there was an intentional assault and battery. I would also note that the Barrero's testimony, even though it was elicited as a prior inconsistent statement, there was no defense counsel did not ask for the instruction, and I would suggest that because he did not ask for a prior inconsistent statement instruction, that statement could be considered substantively. But
do you agree that differs slightly from the theory chosen by trial counsel at trial? That is your argument that the record supports an intentional assault and battery.
I would argue that the record does support it, but certainly there was more focus on the reckless theory. Does that answer your question?
Yeah, that was the theory that was argued. Correct?
Yes, but again, I would say that there was support, and the judge did. It was not improper for the judge, I would suggest, to give the instruction on intentional assault and battery with a dangerous weapon. Here, in order to prove the reckless theory that the defendant engaged in actions that caused bodily injury done with a dangerous weapon, and her actions amounted to reckless conduct. Here, it's clear she intended the conduct that resulted in the touching. She intended to drive. She knew that the victim was right there. She drove, and I would suggest that was the act. And I would suggest that although perhaps the judge could have elaborated a little bit more on causation, I would suggest that there were no superseding actors here. I would suggest that the jury could understand in this instant what cause meant, that the defendant engaged in actions that caused a bodily injury.
But of course, if the passenger had not grabbed the aunt, then there would have been no dragging through the parking lot and no injuries, correct?
Well, I would dispute that slightly, because I believe it. And this is where I dispute my brother's recitation of some of the facts, where the defendant and the front seat passenger are arguing. A victim goes out to empty her trash. She says that they're arguing very loudly, so she tells them to stop. And at some point, she says they're yelling, and then she doesn't use a pronoun, but she just says, "Start yelling at me." And she goes over, she's by the passenger window, and although she is slightly, I hate to use the phrase all over the place, she's very nervous, it's clear, when she testifies, but he lets go. So she grabs onto the door, maybe grabs onto him. It's a little bit unclear exactly what happens, and he does grab onto her, but I think it's very important, and again, this is in the light most favorable to the Commonwealth, when the defendant puts the vehicle into drive, when she starts to drive, he lets go. The male passenger lets go. He is no longer holding her. So I would suggest that she's not being dragged because she's being held by him. And that's why I would dispute the superseding, because he has let go. And this isn't a Ferrari where it goes from 0 to 100 in a second. There was a moment. So I would suggest that was not a superseding act.
And so what does the evidence tell us about why she was dragged through the parking lot, if not being held by the passenger?
Because she's afraid. I think it's clear. Well, she says that he lets go. She's holding on because the vehicle's now moving and she doesn't know what to do. She's it's very, very early in the morning. She's worried about her dog.
Letting go would seem to be a reasonable option in those circumstances.
I don't know. She's a 52-year-old woman. It's early in the morning. She's worried about her dog. I think, I'm not sure. I think either would have been reasonable, to either hold on or let go. I'm not sure. But I would suggest in the light most favorable to the Commonwealth that the Commonwealth proved this case by the reckless theory. Are there any additional questions for the Commonwealth?
Just one last question, the same question I asked Mr. Madison regarding the instruction. Is there any authority one way or the other on the requirement to give a more elaborate instruction on causation in these circumstances?
I don't believe that there is a case on point that indicates a more elaborate instruction. Certainly, the Marahino case, which is assault and battery SBI case, it talks about causation. There's a little bit more language, but I would suggest, and certainly there's in manslaughter cases, and there's certainly more. There is instruction given, but in these sort of circumstances, I would say that there is no authority that I have seen.
Thank you.
If there's no further questions, the Commonwealth would rest on its brief.
Seeing none, thank you both. We'll take the case under advisement. Just want to say, well argued, well briefed, and Attorney Madison, even though you sort of disavowed Attorney Combs, you both.
We are live and on the record.
Thank you very much, and good morning, counsel, and welcome to the Appeals Court oral argument session for November 6, 2020. As you know, this case is being argued on Zoom and being simultaneously streamed on YouTube at the Appeals Court YouTube channel. I just love saying that. We follow the same customs as in the physical courtroom, 15 minutes per side, no rebuttal. You do not have to stand. Only one advocate will speak at a time, and the other one will be muted while the other is speaking, but we can still see you, so please keep reactions and gesticulations to a minimum. The proceeding is being recorded and will be archived and available to the public as it's available now. It'll be available afterwards as well. And once we start going, a time clock will appear where the seal is, and we'll give you the 15 minutes. As always, we've read your briefs and we're familiar with the case. Although you're free to use all 15 minutes, we won't hold it against you if you don't. And so this is a Commonwealth appeal, right? So Attorney Kenny.
Thank you. Good morning.
I'm sorry. Calling the case, it's Commonwealth versus DeFrancesco 2020 P162. Thank you.
Thank you. Good morning. May it please the court, Jessica Kenny on behalf of the Commonwealth. This is the Commonwealth's appeal. We are asking the court to reverse the motion judge's ruling suppressing items that were seized as a result of a search warrant that was obtained specifically for a motor vehicle. I will point out that the defendant never challenged the sufficiency of the other search warrants that were issued in this case for a home, but they did challenge the sufficiency of a motor vehicle. And the judge, relying on Commonwealth versus Wade and 2 unpublished decisions, decided to suppress the fruits of that search. So the Commonwealth suggests that Wade is not applicable here. Wade was a split court decision and a very, very bare bones narcotics investigation. In Wade, they had it was 2 controlled buys that occurred, and in one of them, they observed someone going to and from the house before and after, and in the other, they only observed a person returning to the home afterwards. But there was no other evidence linking the motor vehicle that was used. In our case, is significantly different. What I suggest you have here, again, based on an opinion of a 16-year veteran of the Brockton Police, and not just any other type of detective, but a narcotics trained detective who details at length in his affidavit his experience with narcotics investigations and a significant amount of training that he has gone through related to these types of cases. But here you have, I suggest, 3 controlled buys and 1 uncontrolled buy occurring over a 5-week process. But most alarming is the way in which the defendant is utilizing a straw man and a number of rental vehicles to make these transactions. And that is significantly important because
the problem, I'm sorry, and please, you pointed out that there's no challenge to the search of the home. Clearly, there's drug dealing going on here. I don't think the defendant disputes that. The question is, and there's been this rotating cars. What is the evidence that he's storing the drugs in the cars? And doesn't the fact that there are rotating cars kind of take away from that conclusion as opposed to strengthen it?
No, it's exactly the opposite. I'm sorry, did I interrupt you? I apologize.
Tell me what.
I think it's exactly the opposite. So again, it's the lengths at which the defendant is going to distance himself from these vehicles. And that's exactly what they discussed in the Dion case. In that case, there were absolutely no controlled buys whatsoever. That was the B&E case. And it was just the fact that the defendant was parking the car down the street and that he was trying to hide the key to the car at the time he was physically being arrested. And that, I suggest, is much less furtive than what you have the defendant doing here. So he goes through 3 different cars in a 5-week period. He's turning them over in rapid succession. He's not renting them in his own name. They're rented in a straw person's name. At one point, he stopped while operating the vehicle, and to further distance himself from that vehicle, he switches seats with the person who's a passenger in the car, who also happens to have a lengthy record for narcotics and firearms violations. So he's doing everything.
Can I interject a question, please? Wouldn't one interpretation of that be that by distancing himself from the cars and the cars from the residence, he was insulating the residence from investigation, and therefore that is the residence would be a safer place to conceal drugs as opposed to the vehicles?
I think it's the opposite. His residence, I mean, again, you have someone who's there's previously been probable cause to charge him with a drug offense, who lived at that address at the time of that prior drug offense. His address is still at the RMV, is registered to that address. He's doing nothing to conceal his ties to that address. He's coming and going freely from there. It's still where his license and for the RMV is registered. It's where he knows the Brockton police previously knew he lived at a time when there was probable cause that he was dealing drugs. Contrary to what he's doing with the motor vehicles, he is going to great lengths to make sure that those motor vehicles are not linked to him. And that goes directly to the heart of trying to hide something in there, trying to hide something about the motor vehicle. I point out it's not just the likelihood that he's storing drugs there. It can be anything. It can be the money. It can be the ledgers. It can be the paperwork. It can be the baggies that he's using to package up the narcotics and sell them. Anything was applied for in the search warrant. And you have case law that talks about how once you establish that someone is using an address or a place to sell drugs, very little more, if anything, is needed. So you have, right in the Wade case, you have that Dion case. And I think that that's so important. Again, there are no controlled buys in Dion whatsoever, using a car or not. And they say there's probable cause to search the car because of those furtive motions that he's using. And all the defendant is doing here is using furtive motions to distance himself from that car. Additionally, you have the Burt case. And I know Burt's a little different because it talks about, it was a coin stealing operation from parking meters. But one of the factors that they relied on in Burt was the fact that they had assigned work parking spaces. And instead of using those, the defendants were utilizing street parking, again, to distance themselves from things that could be tied to them and to their name. So this is something.
Are you asking us to infer that this defendant would have known the law of curtilage in Massachusetts and therefore parked the car on the street?
So I understand that that's a bit of a leap. I mean, we do have a defendant who does have prior contact with the criminal justice system as it relates to narcotic offenses. And we know that at least one of his compatriots has an extensive record as well as it relates to them. And we know that the case law of curtilage, I think some of the cases cite back to the 1950s. This is very well established law. Even assuming that he doesn't understand the curtilage law, if you're trying to distance something that's registered to you, your home, where your RMV address goes back to, versus something that you're using to do something illegal, and in this case, multiple cars that he is transferring through at a rapid basis, one of the best ways to do that is to just not park it at your house, so that when police do surveillance, it's not sitting in your driveway, it's not tied to you, it's out on the street or across the street or somewhere else. It's distancing himself. And I suggest that in this instance, that makes the car even more suspicious than the house, because of the lengths that he is going to make sure, whether it's for a legal reason based on curtilage or just a common sense reason. Hey, I mean, I don't know anything about that car. That's not even in my driveway. It's not even registered in my name. I don't even drive that car. It has nothing to do with me. Whereas opposed to his address is something that is out in the open and that he's gone to no lengths to try and conceal because he's still using that with the RMV to register his license and his address. Again, I know these cases are very, very fact specific, and I would just go back to the fact that Wade is a very bare bones investigation, and case after case that has come after Wade has distinguished Wade, finding anything even slightly more inculpatory, if you will, that can tip the balance of the scales in this case. So between the fact that we do have a very lengthy investigation, we have surveillance going on for approximately 5 weeks. We've got 3 controlled buys in this case, 1 buy that's not even controlled, but that the police just witnessed. I will point out that the judge, I believe, made an error in her factual findings when she said that there were no transactions that occurred inside the vehicle. We know for a fact that the non-controlled purchase occurred inside the vehicle because it's described that way. But even with the
when you're saying which is the non-controlled purchase, is the first, second, third, or fourth?
Yes, it was the one that occurred on the 22nd of August. I think that would be the 3rd in time. And that is the one that occurred at the playground at the time that the defendant was utilizing the Altima.
Okay.
But in that one, it's very descriptive that the transaction occurred within the vehicle. But even in the purchases that occurred with the informant, where again, the officer generally is more vague because they're trying to protect the identity of the informant. But even in those cases, when they're describing the transactions that occur, they're using the location of the people in the car to describe who they are. And I think that that's telling language, saying that he had a quick meeting with the operator of the motor vehicle. And you know that the police are surveilling this entirely. And I suggest that if it had gotten out of the car and if it had occurred outside of the car, there would have been language that said, we saw them outside of the vehicle, we saw them exchange an item, but we couldn't see what it was. And then when we met with the CI after for the debrief, he indicated that the item that was exchanged was the narcotics. You have none of that, and instead you have this descriptive language about the fact where the people are sitting in the car at the time the transactions are occurring, and I think there's a reasonable inference that means that they're using the inside of that car for those transactions. There was an issue in Wade as well with the timeliness of it that we don't have here. In Wade, I believe it was 5 days after the last controlled purchase that they executed the search warrant, and in this case, they were granted the warrant within about 24 hours of the last transaction, and then they executed it just 2 days later. So even going from the last transaction to the time they executed, it's only 3 days. It's significantly shorter. And that was a concern in the Wade case. It was the timeliness. They discussed that of waiting that long. I suggest that they're using common sense. You don't have to eliminate every other possibility, obviously, that there's a reason that the defendant is renting vehicles through a straw man in the manner in which he is and distancing himself. And the reasonable inference, and what this officer who had this type of training and experience believed, was because he was using it to further his drug distribution business. We know he was using it to meet up and sell drugs. I suggest that it was a reasonable inference that it's likely he was hiding something that was inculpatory as it relates to that narcotics enterprise in that vehicle, whether it was the phone he was using, the money he was making, the ledgers that he was keeping to keep track of who he was selling to. All of that is incorporated into the search warrant, the application for the search warrant, and it was granted. And there is a basis to believe that he was hiding something, a strong basis, I suggest. It is more than Wade, what we have in this case. And Wade is very bare bones, and the cases that have come after Wade have differentiated that.
I have a couple of questions. Can a search warrant set forth probable cause that the same item is in two different places?
Absolutely. I believe, especially something like narcotics, because as we know, and as this investigator knows, narcotics can sometimes come in bulk, and then they can be repackaged and they can be distributed at different times in different places, in small amounts, in large amounts. And as we know from the cases that talk about large scale drug enterprises, there's often numerous addresses and numerous vehicles and numerous targets, if you will, that are tied to this. And I believe that case, is the Santiago case. And again, I believe in that case, that's the large scale drug operation case. And there were, I believe, 1 or 2 addresses and a vehicle that were applied for in that case. So it's absolutely, I suggest, not even just possible, but likely that when you get to this large scale, again, someone who's renting multiple vehicles in a 5-week period and selling at least 4 times that the police are able to observe in this 5-week period, you absolutely can have drugs located or proceeds or ledgers located in more than one location. In fact, there's a case that says that it's more likely they're going to keep those items separate from their drug stash, keep their proceeds, keep their ledgers separate from the drug stash. And so it makes it more likely that there will be multiple locations.
Are you, it doesn't sound as though you're making the argument advocated by the dissent in Wade, that there could have been PC for the records being in the vehicle. And I understand that might have been precluded by subsequent case law. Are you making that argument?
I think that the case law that has come is clear that defendants can and often do keep these items in different places. And the point I'm making is he's doing something illegal with those cars. And that is obvious by the way that he's insulating himself and the way that he's turning them over. And so the question just remains, is it possible that he's storing his drugs there, or likely or probable? Yes. Is it also probable that maybe he keeps the drugs in the house, but he keeps the money in the car, or he keeps the cell phone in the car that he uses to arrange these? Yes, because again, as we know with experienced drug dealers, which we know this defendant is, and we know that his friend is, they know that if they can separate the stuff out and keep it in different locations, and the case law supports this, it actually helps insulate them from the illegal activity. We see this all the time. One guy has the money, one guy has the product. It's just as likely when someone is operating a drug distribution enterprise where they're using their address and multiple other cars that are being turned over in rapid succession.
I have a question.
I'll yield the rest of my time if there's no other questions.
I do have a question. Suppose the police had, instead of getting a warrant, they'd arrested the defendant after the last controlled buy. There's a lot of I think you'd have probable cause at that point that he was involved in a drug deal. Would they be able to search the car incident to that arrest?
Absolutely. And there are cases, again, where the Commonwealth has made that argument before, that if they just waited till right after either a controlled buy, or even in the instance like the buy on the 22nd that occurred at the playground, that was not a controlled buy, but where based on their training and experience, they believe they had observed one. If they had probable cause at that time to stop the car and to arrest the defendant, they absolutely would have just been able to search the car at that point, especially if it had been immediately used. And one of the cases cited in my brief discusses the immediate use of the motor vehicle. I apologize, I'm trying to look at my notes right now. It is in my brief. I know I just read it last night, but there is a case where immediately after the search was a basis immediately after the CI buy was a basis for them to search the car. Thank you. Oh, I'm sorry, I can't hear you.
You're muted. You're still muted.
I don't know how that happened. Thank you. That's what I was saying.
Thank you.
And we'll turn to Attorney Rosil.
Thank you. Good morning, and may it please the court. Attorney Luke Rosil for the appellee, DJOY DeFranceesco. In this case, the Commonwealth cannot adequately distinguish Wade. Starting with the facts in Wade as compared to the facts here, there are 2 controlled buys in Wade. In fact, there were 2 controlled buys involving this car in this case, right? The other buys involved other rental cars and not the Rogue that was the subject of the, oh, I'm sorry, I see the clock hadn't started there. So
No, you're fine.
And so there were only 2 controlled buys involving the Rogue that's at issue here. The others involved the rental car. And I think to your point, Justice Massing, that you made at the outset of my sister's argument, doesn't it make it less likely that the cars are being used for storage, the fact that there's multiple rental cars? There is some case law speaking to that. It's not in the briefs. I saw it today as I was reviewing. It's a case called Escalera, 79 Mass App Court 262, in which the court ruled that the use of multiple cars made it likelier that the residence was being used to store drugs rather than the cars. The SJC did take that case up on further appellate review, did end up affirming the judgment below on the same in the same way that the appeals court had ruled it would be affirmed. So that may affect the precedential value of the appeals court's opinion in Escalera, but still as for its persuasive value. And I think it's a common sense inference that if you've got multiple cars, you're incurring more risk each time you take drugs out of one car and move it to the next car. If you're going to be using the car,
Mr. Rosil, if you are, isn't it also logical to infer that if you are distancing yourself from rental cars by renting multiple cars over time, you're concealing your connection to those vehicles, at least? Would you agree with that?
Yes. And I think the concealing of the connection to the vehicle certainly speaks to the use of the vehicle as part of the drug enterprise, but it's just the facts in this case did not make that concealment a reason to believe that the cars are being used to store drugs as opposed to being used to transport drugs. The defendant would have the same incentive to conceal that connection to the vehicle that he's using just to transport the drugs as he would have if he's using the vehicle to store drugs. Plus, we have the fact that the vehicle's being parked outside of the driveway out on the street, which I think the judge below took as a reason to rule that that was less likely you're going to be storing the drugs at a location outside of the scope of your house, because you actually, and to your point, Justice Grant, about are we ascribing the level of sophistication to this defendant that he knew about curtilage law? I think that is a rather strained argument, but it also cuts in the opposite direction because you have more constitutional protections in some respects when you park the car in the driveway. Then you need a warrant to search it. You don't get the automobile exception that would otherwise apply. The other thing,
a question. Let's say the police had gotten a search warrant only for the house or the apartment. Could they have secured the Rogue during execution of the search warrant on the premises, just in case there were drugs there, and waited to see if they found them in the house, and then if they didn't, get a warrant for the vehicle?
That's an interesting question, Justice Grant. I think it would come up in this fact pattern. What would have to happen is they're executing the search warrant on the apartment. The car is there. No one's moving the car, so there's no need to secure it then. But I think in your hypothetical, Justice Grant, someone comes and attempts to move that car, and the police say, no, we're securing that. You can't move it. I think that would make my argument far more difficult, certainly, that the police could not at least secure that car for the time it would take. But on the facts here, there still would not be probable cause within the four corners of the affidavit to believe that drugs were being stored in the car there. I did also want to speak, hopefully that answers your question, Justice Grant, but back to your question, Justice Kinder, about the relevancy of the rental cars. There's at least 3 cases that speak to the notion that there really is not much weight that should be placed on the fact that there's cars being rented at all. One is Locke. It's 89 Mass App Court 497, where the court ruled, quote, the additional fact that the rental agreement was not in the name of the driver adds nothing to the equation. There's another case called Bartlett, 41 Mass App Court 468, where there was a whole slew of 8 different rental-oriented observations. It was rented by a non-occupant of the car. It was a local trip, so the police said that's suspicious. Why would you rent a car for a local trip? The officer had specialized training indicating that the airport from which the car was rented was a place where drugs would often come in. And yet with all of these rental-oriented observations, the court there ruled that it was, quote, 8 innocuous observations, 8 zeros. And most recently, the SJC in Tavares, 482 Mass 694, there, none of the vehicle's occupants was listed as an authorized operator on the rental agreement. There were conflicting explanations from the occupants of the car over who rented it, and that didn't even rise to the level of reasonable suspicion. So this notion that renting serial cars connotes some degree of suspicion about criminal activity, perhaps, and perhaps it supports that inference that the defendant was trying to put distance between himself and that car. But that doesn't make it any more reasonable to infer that the cars are being used to store drugs as compared to being used to just transport drugs. It's
Would
not as though
would this search warrant have authorized police to swab the steering wheel and the stick shift to see if there were trace amounts of drugs?
if it was a valid search warrant, I don't think that would be outside the scope of the search warrant, Justice Grant. And that kind of dovetails to my sister's argument that it was about, well, there could be ledgers in there, there could be records in there, there could be cell phones in there. I would note that in the warrant affidavit, the PC that the officer says he believes was there was drug PC, not records PC. And I don't think there's any explicit argument in my sister's brief that they were looking for ledgers, cell phones, or anything other than drugs. And so I think this really does rise or fall on the drug PC.
If the police called the enterprise rental car and found out whether or not this vehicle had a navigation system, could they have written a warrant to look for data in the navigation system, evidencing the drug transactions that they had seen?
I haven't put much thought into that hypothetical, Justice Green. It hadn't occurred to me until you just posed it. I suspect they would, but still that PC would just show the car coming and going to these controlled by or non-controlled by locations. So, okay, being used for transport, but it's not clear to me how that PC shows storage. We don't have something in Santiago where the car, during one of the buys, someone's going to retrieve drugs from the car and then selling it at a different point in time. And we don't have the kind of specialized training that they had in Santiago, where the officer in that case said, in my experience, the proceeds from the crime are stored at a different location than the contraband involved in the crime. And I want to get back to this notion that the non-controlled buy happened in the passenger compartment. First, that wasn't the Rogue, that was the Altima. Second, if we look closely at Record Appendix 32, at this August 22nd incident, what we see is that at 11:15 in the morning, the defendant goes out to the Altima, backs it into his driveway, goes back into the house, and then comes back out of the house into the Altima and pulls away at about 11:40. It makes no sense that the defendant would back the Altima into the driveway, leave it there for some appreciable time, go back inside the house, and then drive away in the Altima if the Altima was where he was storing the drugs, right? You'd have no need to pull it into the driveway, go back into the house, and then come back out and leave. The inference there is the drugs were in the house. And I think that kind of dovetails with Escalaro.
But the police don't need to have probable cause that the drugs were in the house on that day, in the Altima on that day. They need to have probable cause that they were going to be in the Rogue on the date of the search warrant.
Precisely, which I think even removes it even further from evidence of probable cause that there were drugs being stored in the Rogue. It is evidence that the defendant was not engaging in some pattern or practice of storing drugs in the cars he was parking across the street. Regarding the prior arrest, the Commonwealth in their brief refers to a prior search of the residence as giving reason or incentive to store the drugs in the car. That prior search is not in the warrant affidavit. It's not part of the calculus whatsoever. All there is in the affidavit was there was a prior arrest for drugs and that address was listed. And I think my sister also mentioned the Dion case. So I want to make a factual point on the Dion case and a legal point on the Dion case. Fact-wise, we've got the defendant trying to hide a key on his person during the booking process. That definitely connotes there's something in the car at that point in time when he's trying to hide the key. There had been previous break-ins at the apartment. We don't have any previous break-ins or other incentive like a previous search in our affidavit to give an incentive to store the drugs off-site. So those are the factual distinctions, but the legal distinction is important too, because the legal question in Dion was not whether there was probable cause to search the car. It was more of a Frank's question, right? The defendant argued in Dion that the police had included misleading information in their warrant affidavit and had left out exculpatory information that should have been part of the affidavit. And that was the analysis on which the court embarked. The court was not asked to make just a simple probable cause analysis on that record. Rather, it was whether information had either been put into the affidavit in a misleading fashion or had been left out of the affidavit that should have been put in. And so Dion does not support the Commonwealth's position here, nor does Burt, right, where the traffic officers are seen taking coins out of the parking meters, putting them in cars over the course of a 5-month investigation, completely distinct from this case here. The Dillon case relied upon by the Commonwealth, 79 Mass App Court 290. There was no ruling on the probable cause. It wasn't an issue in that case. But in any event, the informant in that case said, I saw him storing drugs under the hood. There's nothing like that here. No hide compartment, like, you know, sometimes there's a secret compartment somewhere in the car that would need to be accessed. There's just no PC to believe that it was any likelier that the defendant was using the car to both transport and store drugs than it was to believe that he was using it just to transport drugs. 2 other cases I'll mention here. The Hardy case is 63 Mass App Court 210, where the court reasoned that it was unlikely the defendant would store a large amount of drugs in a car parked outside the house while they were home. And to support that reasoning, the Hardy court relies on O'Day, a Supreme Judicial Court case, 440 Mass 296, also saying it's unlikely that a defendant's going to be storing drugs in the car parked outside rather than storing them in the home. And really what it comes down to is this case cannot be adequately distinguished from Wade. Wade had the 2 controlled buys in the subject vehicle, 2 controlled buys in the subject vehicle here. In terms of being in the passenger compartment, the 128 decision, Maurice, 88 Mass App Court 1107, that was 3 controlled buys, all of which took place in the passenger compartment. And I understand it's only persuasive authority, but still a panel of this court ruled that did not serve to distinguish that Maurice case from the Wade case. And there was one other point that my sister made that I made a note of that is escaping my attention right now. The return of the car to the apartment, right? There was at least one instance where the police elected not to follow the car after they observed the alleged buy. And the Commonwealth is arguing because the police didn't see it go back to the apartment, that provides evidence of storage. The fact that the police decided not to follow the car does not support a probable cause that the car was being used to store drugs. An absence of evidence does not solidify the Commonwealth's case. And so I think the Santiago case is clearly distinguishable from here, from the specialized training and using 2 cars in one deal. The use of the serial rental cars makes it less likely that any one was being used to store drugs rather than just to transport the drugs. The extent of sophistication that the Commonwealth ascribes to Mr. DeFrancesco, I think, is not just a reasonable inference, it's piling inference on inference, and it amounts to speculation.
Can I ask a question before your time goes up?
Please, thank you.
I asked Attorney Kenny and this, do you agree with her that if they'd arrested him on the spot, they could have searched the car?
I think they would have. They'd certainly have more solid PC to do it then than they have here. And I'm not quite prepared to make that concession because that's actually just a preface. So assuming that they could, isn't it kind of a perverse incentive that they could search without a warrant, but if they get a warrant, they can't? No, Justice Massing, and here's the reason. They can search without a warrant if it's with immediacy. Here, there was a 4-day lapse not quite the 5-day lapse in Wade, but a 4-day lapse between the last September 10th controlled by and the September 14th execution of the search warrant. And the search warrant return does indicate that it was a September 14th execution. And that's at Record Appendix 26. And so there is no perverse incentive, because that lapse of time brings this case outside the scope of those cases where there was PC to search a car immediately upon the witnessing of a drug transaction involving that car. And so I don't think that affirming the judgment below would risk, or affirming the order below would risk the creation of any perverse incentive. So really, there is no adequate distinction between this case and Wade. There are myriad distinctions between this case and Santiago, this case in Dion, this case in Burt. And for all of those reasons, we ask that the court affirm the order below. Unless there's any other questions, I'll otherwise rest on my brief. Thank you, Your Honor.
I have a quick question picking up on something you just said. Are you arguing that the information about the drugs was stale because of the passage of those 4 days? Or are you arguing that there wasn't PC, that the drugs would be in the vehicle, or both?
Both, I would say. I think under your hypothetical, Justice Grant, or maybe a hypothetical worth considering, is what if the Commonwealth just went and searched the car without getting any warrant on September 14th, when the last thing that they had witnessed happened September 10th? That's a clear staleness argument. And I think they kind of dovetail with each other, that you can't wait 4 days after a drug deal to then go and search the car based on that drug deal from 4 days ago. So I think that staleness is part of the analysis as well. Unless there's any other questions, I thank the panel. Thank you.
Great, thank you both. Extremely well argued on both sides. Argument is being held on Zoom and live streamed on the Appeals Court YouTube channel. Despite that, we will try to follow all of the normal customs of the courtroom. Basically, we have 15 minutes per side, no rebuttal. When you are not speaking, you will be muted, but we'll still be able to see you. So please keep your reactions to a minimum. The other thing that Attorney Krause, you're free to stand, but you don't have to if you don't want to. Whatever's more comfortable. Once you start going, the clock will show up where the Appeals Court seal is. It'll show you 15 minutes. Proceeding is being live streamed now. It's being recorded and will be archived. As always, we've read your briefs and we're familiar with the case, so you can get right into it. And so calling the case, it's 19P966, MARGO GATES and others versus Mountain View and others. Yep. So, and Attorney Krause, I believe, are you the appellant?
Yes. Good morning, Justices, and thank you, Justice Massing, for the accommodation, but I'm too old and been at this too long to sit in front of Justices of the Appeals Court. May it please the Court, my name is Robert Krause, and I'm here on behalf of the appellants, Mountain View MHC LLC and Morgan Management. And I'd like to start with the facts because it's somewhat confusing and it's complicated. This case started in 2007 and it went to judgment, a clarified judgment in 2019. This is a process that has gone on for 12 years. It started with a petition for a rent control increase in the town of Ludlow before the Rent Control Board. This is a 74-unit manufactured housing community. And there was a petition to increase rents for sewer improvements and other certain costs. There was a Rent Control Board composed of 5 members, one of whom never participated because of ill health. The other 4, 2 of whom were representatives of the manufactured housing communities within the town. So there was a 4-member board.
Are those two actual residents of this
Yes, Your Honor, I believe so. And what happened was they had 4 hearings where the board had counsel throughout, the residents participated, and they scheduled a hearing in January of 2008 to finally make a decision. At the penultimate moment, the 2 representatives of the mobile home park resigned, leaving a lack of a quorum. And during 2008, counsel for the board had suggested to the appellant, the only applicant, Mountain View, that it reapply. Instead, in the fall of '08, a complaint was filed with the Superior Court for mandamus and constructive approval because they'd been at it for a long time. Ultimately, and I'm trying to be wise with my time, on December 24th, 2009, a justice of the Hampton County Superior Court ordered a remand back to the board with a date certain for a decision by the Rent Control Board, and ordered that any rent applied be retroactive to the date of the application, evidently because of, for lack of a better term, the shenanigans in the process. These two individuals who had recused themselves had participated in prior hearings. They knew what they were doing. And I think they understood that they were going to continue the process.
Can I say that again? I didn't quite understand what you said there. Those two people?
The two residents who recused themselves, Your Honor, or Justice Massing, had participated in other rent control process. They'd been on the board for a long time. And at that point, when they resigned, the board had no quorum for which to act. They effectively shut down the process, so no rent increase and no decision could be granted. May I continue?
So in the Superior Court case, though, is there anybody? I mean, none of the tenants are represented as tenants. I mean, the defendants are the board members, right, of the Rent Control Board.
But
somebody as tenant who's saying, well, Judge, no, you can't retroactively raise rent. That violates the statutes.
Well, Your Honor, there's no statute that prohibits retroactivity of rents, first of all. And in fact, the residents knew about the process. They had an attorney in 2010, Thomas Vincent. He wrote a letter to the Board of Selectmen and said, I'm going to pursue this. I'm going to file a claim. They never filed an appeal to the Rent Control Board, and they never filed any action with the Superior Court to try to contest that decision. It was only in 2011 when there were notices to quit filed because people weren't paying the increased rent. Then in the fall of that year, 2011, 4 years after the petition, that they filed a counterclaim claiming that the Rent Control Board had exceeded its authority and the decision of the Superior Court was wrong and that they should have a bite at the apple. Now, the appellant filed, the only appellant, because Morgan Management only added in 2014, we filed a motion to dismiss in the fall, December of 2011. 19 months later, in July of 2013, the judge of the Western Division Housing Court converted a motion to dismiss to a summary judgment. And what did she do? She didn't remand the case back. She claimed that she had a lack of factual foundation. It's at the record in the decision, volume 2, pages 72 and 73. She didn't have the facts with respect to whether the sewer pass-through was legal, but she didn't remand. What she did is acted as an appeals court for the decision of the justice of the Superior Court. Catalano, which is clear on its face, 37 Mass Act 377, I think it's a 94 case, claims that once matter has gone to judgment, another judge cannot act as an appeals court. They should have taken it up to the appeals court. But let me just go through the facts again.
Actually,
I'm sorry, let
me stop you. I've got a few questions. I understand your basic argument is that they missed their chance that your clients acted under the permission and the blessing of the Superior Court and the Rent Control Board. The tenants sat on their rights, didn't exercise them. But let me ask you on the basic question. Do you disagree that you're not allowed to pass on the costs of fixing the septic or the sewer to the tenants?
It all depends, Your Honor. The statute and the regulations address a factual issue as to whether the standards went in before or after that particular resident took residency. You can't to residents who are already there. You can for residents who come later. Yeah, but it's a factual matter that Judge Fine clearly says, you know what? I don't really know, but I don't really care. I'm still going to overturn the Hampton Superior Court, and I'm going to fine for declaratory judgment. I'm not going to give them a 38 appeal because they clearly knew about it and they didn't act within 30 days. Justice Massing, I don't have to tell you, in the Bower Sachs case that went to the U.S. District Court. You and your panel saw or decided a case where a timely appeal was not filed. The fact of the matter, Massachusetts law is very clear. I cite to Doughton, which is at 395 Mass 13 and 85 case, and Pierce 369 Mass 804 76 case. The standards for appeal are obligatory. They're mandatory. Why? Because finality of decisions, as the SJC has said, a judgment is a solid record, a solemn record. Parties have a right to rely upon it. But what Judge Fine did is she took jurisdiction, made all the decisions by summary judgment, which means that your standard of review is de novo. And I refer you to the DeWolf case, 464 Mass 795, a 2012 case, where your standard is not abuse of discretion, but de novo. Ultimately, justices of the appeals court, about 12 years later, there was a trial, such as it was, where evidence was presented, no witnesses, on damages. And ultimately it came down to about $1.8 million, a decision that basically impoverished the park because it's in excess of the value of the community. Now, my arguments with respect substantively, and the facts are so tortured that you have to understand when the decision came down from Judge Fine, we filed a motion for separate and final judgment so we could bring it to you and your court because we thought it was so important. 15 months later, she denied that motion. So literally, this has been a 12-year process where fees have been built up and claims of abuse have been made. My arguments substantively are four. One, there's no jurisdiction for Judge Fine to have made those decisions. Two, Morgan Management is not a party. 393A doesn't apply. And lastly, but probably most importantly, finality of a decision is critical if our system is to work. I've already told you that Judge Fine basically said, I'm going to fine for declaratory judgment because I'm going to use the Swansea case. And the Swansea case stands for, are there special circumstances of public import? But Swansea dealt with an entire retirement system. We got 74 units in a small, finite manufactured housing community. And Swansea says more persons than the parties to the case have to be involved.
Well, I mean, don't you have here, you have a conflict between a finding of the Rent Control Board on the one hand and something that's regulated by the Attorney General on the other hand? There's a conflict there. Isn't that an issue of public importance?
Your Honor, the Rent Control Board was represented by counsel. They rendered a decision and went to an agreement for judgment, and the Superior Court concurred. I don't see a conflict as Justice Massing as you're suggesting.
There's an important public policy thing that the regs specifically say is a 93A violation that was completely overlooked.
Well, Justice Massing, if there's to be any consideration, and again, time is of the essence because we've gone through 2 years, and let's take your point as stated. There is a time for which to raise these issues. 18 months.
I have a question. What do you do with Judge Fine's finding that, although this is on page 11 of her findings and rulings, page 73 of the second volume of the record appendix. Although it's clear that the plaintiffs all knew about the board's decision at or around the time it issued in February 2010, the record does not establish satisfactorily that the residents were properly served with the original notice of claim. So how do you?
Well, the record, there's an affidavit in the record, Justice Grant, where the participation in the hearings was hand delivered by the manager of the park. The hearings were well attended. I wasn't the counsel at the time, but the hearings were well attended. The residents appeared on February 4th of 2010. There was a hearing at the Rent Control Board where the residents were actually in attendance, where the rent increase went into effect, which ultimately became part of the agreement for judgment. Even Judge Fine, as you'll see in her decision, says, I'm not going to give them the 30-day appeal because they knew about it. And they clearly knew about the decision of the Superior Court. In the record, there's a notice to all the residents, we got to get together, and we hired an attorney, Tom Vincent. And Tom Vincent, in 2010, writes to the Board of Selectmen and says, on a 3-page letter, I'm going to take this up to the court. We're going to take some action. We're going to review this. There's some impropriety. The Judge Fine could have remanded this back. The residents had a lawyer. They could have filed an appeal. They could have filed an administrative appeal with the Rent Control Board. There was a variety of avenues that they took, just as the system allows. But Catalano doesn't allow Judge Fine to overturn the Superior Court. You have to exhaust your remedies. And in fact, what Judge Fine did is wanted, in our impression, no offense, she wanted to render a finding, and then she worked backwards, what we argue, to contort Swansea. We don't see Justice Massing the same kind of conflict that you may perceive, because there was no factual finding on it. Even Judge Fine says it on page 72 and 73 of the record. Now, on your 93A claim, this is important. And you've heard this a million times because you're familiar with it as bail court justices. 93A is supposed to address egregiousness, so-called smell test. If it's wrong or it's deceit or there's something improper about it, what do my clients do? They send out a notice indicating the Rent Control Board decision and the decision of the judge of the Superior Court, and they passed along those expenses to improve their own community. Now, the appellee makes reference to a case, the Montanez case, which is a well-known landlord-tenant case involving egregiousness. In that instance, the landlord rented a condemned apartment. That's not what's happening here. It's almost as though form over substance is applying to penalize the appellants, one of whom was added in the case in 2014, 7 years after the petition. That's the other argument. They shouldn't be in the case. Justice Massey, Justice Kinder, Justice Grant, I got 59 seconds, and it's almost like the $1.8 million question. Finality must serve the system. It must. 12 years later, it's still going on because it's still in litigation. Our system is geared towards finality. The residents had lawyers available to them. They had remedies available to them.
I'm sorry, one more question.
Take advantage of them.
I'm sorry to interrupt you. One more question. Is it, we touched on this briefly earlier. Do I understand at some point in 2010, after the Superior Court case, the tenants were told, you owe us retroactive rent increase for 3 years. Is that correct?
In 2010, there was discussions with the residents. My clients didn't expect to get paid because they didn't. Remember, the rent went from $128. Let's just talk real figures.
So are they allowed to do that? Are they allowed to do that? Say you owe us back rent for 3 years? Back we retroactive payment.
Justice Massing, I'm sure my brother will argue no, but this is based on a decision of a Superior Court judge. If they disagreed with that, then they should have taken an appeal to your court. The idea is the judge, remember, the process started in 2007, 4 hearings, 2 residents, knowing what they were doing, denuded the process by resigning. Well, they claim a conflict of interest. How can that be? The regulations.
Okay. Again, I'm sorry to interrupt you, but your time has elapsed. And
thank you very much, Justice. I will now sit down.
Okay.
Thank you.
Attorney Heisler.
Yes, excuse me. Thank you, Your Honor. My name is Hugh Heisler. I'm appearing here on behalf of the named plaintiffs and the class of park residents that they represent. There is no question in this case, and the landlords frankly do not dispute that they sought retroactive and prospective rent increases to cover the cost of bringing the sewer system in the park into compliance with existing minimum standards under applicable state law, in particular Title V, all in direct violation of Attorney General's regulations explicitly prohibiting such increases. There is also no question, and the landlords do not dispute, that they turned around and attempted to unilaterally impose these illegal rent increases with defective notices which failed to terminate the existing tenancies of park residents and failed to give them the option to enter into new tenancies at the increased rents. Also, all in violation of applicable manufactured home park regulations of the Attorney General and long-standing landlord-tenant law. Judge Fine ruled in terms of the timing of this case and duration. Judge Fine ruled in 2013 that these increases were illegal, yet here we are. There's also no question that these actions, these unlawful actions by the landlords, also constitute violations of Chapter 93A under the Attorney General's regs. The entire defense of the landlords in this case appears to hinge on what amounts to a legally and factually unsupportable argument. In particular, they argue that the residents were somehow precluded from pursuing their claims for damages and otherwise under Chapter 93A because they did not file timely appeals of either the Rent Control Board decision or the Superior Court judgment. But no such preclusion applies here. Neither the Rent Control Board decision nor the agreement for judgment, I would emphasize, entered in the Superior Court mandamus proceeding barred the tenants or bars the tenants from obtaining full relief from the Housing Court under their Chapter 93A claims. I just want to highlight a couple of the elements that apply in looking at the issues of issue and claim preclusion applicable to this case. Under either one of those doctrines, the party against whom preclusion is being asserted must have been a party to the first proceeding or in privity with the party.
You're talking about the Superior Court action, right?
Well, I'm talking about both of them. Because I mean
the rent control proceedings, there were tenant representatives there, right? They even tell me about that.
The tenants were not. Oh, there were residents of the park who went to the Rent Control Board proceeding, certainly, but none of the residents were represented by counsel.
What about this
throughout the Rent Control Board proceedings, whereas the landlords were?
What about this Tom Vincent? Am I finding the record that they actually were on notice and they had an attorney who ended up not doing anything?
Well, somebody did, but the record is, it's absent in the record as to who Mr. Vincent may have been representing. He certainly wasn't representing any of the named plaintiffs in this case. And he doesn't indicate who he's representing, and he did nothing more than send the letter that's in the appendix. But my understanding is that the landlords are arguing that the tenants are precluded from pursuing their rights under Chapter 93A and separately adjudicating those rights under the separate regulatory scheme established by the Attorney General that addresses the issues that the tenants raised in the Housing Court proceeding. And they're precluded because there was a final adjudication before the Rent Control Board and a judgment entered by the Superior Court. But as an initial matter, I want to emphasize that there's no question that the residents' 93A claim relating to the landlord's failure to provide legally required advance notice to the residents is not precluded, could not be precluded under either doctrine. The unilateral imposition of rent increases by the landlords occurred after the Rent Control Board decision had been rendered and after the agreement for judgment of the Rent Control Board and the landlords was entered in Superior Court. Certainly claims arising out of wrongful conduct that post-dates the conclusion of the prior proceeding cannot be precluded by that earlier decision.
Although they would say to that the Superior Court ordered that we could do retroactive rent increases.
Well, it's certainly our position, and that's part of what was raised with respect to the special circumstances analysis under the Town of Swansea case, was that that it's perfectly clear from the record that the Superior Court in this case never considered or addressed the merits of the landlord's petition for a rent increase or the correctness or legal validity of the Rent Control Board decision. It was a mandamus action. The landlords were trying to, they brought the case, obviously, to get the court to order the Rent Control Board to render a decision. Everything in the mandamus action, and it's clear from the record, was decided by agreement between the Rent Control Board and the park owner. It was sent back to the Rent Control Board by agreement. That's explicitly set out in the margin order entered by the Superior Court. And the case concluded with a filing of an agreement for judgment between the Rent Control Board and the park owners. The only role played by the Superior Court was the ministerial act of entering the agreement for judgment in their docket. There was never any consideration of the merits in this case by the Superior Court. And I would argue that, and here I'm looking at the issue of, certainly of issue preclusion, the issues that the tenants have raised in their 93A claims in the housing court were not fully litigated or carefully decided, certainly not by the Superior Court in the mandamus proceeding, but could not have been decided by the Rent Control Board. It's clear that the issues also were never raised before the Rent Control Board. The 93A, the issues underlying the residents' 93A claims, were certainly not ever raised, considered, much less adjudicated in the Rent Control Board proceeding, nor could they have been. Because the Rent Control Board jurisdiction and authority is very limited. The Rent Control Board clearly has no authority or jurisdiction to enforce the rights and remedies available to tenants under Chapter 93A or the regulatory scheme established by the Attorney General's office. Their role is.
I want to ask you something that sort of confuses me. The Judge Fine relied on the special circumstances exception to reach a declaratory judgment where there had not been, an appeal of the or a 30A appeal of the Rent Control Board's increase, I guess. Is that necessary for you to prevail on appeal? Do we have to find special circumstance, or is there a different way that you perceive that this could go forward?
I believe not. I believe the court does not have to even reach that issue to conclude that the residents were fully entitled to raise and adjudicate their Chapter 93A claims in the housing court.
And what's the theory on that?
Well, it was in response, I think, to the theory is that that these claims are the 93A claims are separate and independent of the claims that were even available to be considered by the Rent Control Board. Their role, the Rent Control Board's role, is extremely limited under the local rent control ordinance. They only have authority to determine the maximum allowable rent that the landlords can charge. Their limited role is to apply a standardized formula set forth in the rent control ordinance to determine the maximum rent the landlords are permitted to charge. Rent Control Board does not and could not set the actual rent charged to residents of the park. That is accomplished through a contractual process of offer and acceptance governed by applicable landlord-tenant law. While permitted to charge rent up to the maximum level authorized by the Rent Control Board, establishing a new rent for an existing tenant must be done lawfully by mutual agreement of the parties to that tenancy relationship. The landlord can request that the tenant agree to the higher rent, and the tenant's free, but the tenant's free to reject the increase, object to the lawfulness of the increase, either for failure of consideration or violation of other laws, including the manufactured home park regulations adopted by the Attorney General as part of this separate regulatory scheme.
So were they not free when they got those notices to say, we don't accept this and move?
Well, as you heard from my opposing counsel, these cases originated with eviction cases brought by the landlords because the residents had not paid the increase. But in any event, even there are residents who did pay the increase, but the concept of waiver certainly doesn't apply here. Chapter 186, Section 15A specifically states that any agreement between residential landlord and tenant, the effect of which is to waive the notice requirements of Chapter 186, Section 12, is deemed against public policy and void. And that statutory prescription it was probably following on the clear dictate established in Torrey versus Adams, a 1925 SJC decision, in which the court specifically stated that the implementation of a rent increase without a prior termination of the tenancy is invalid, even if the tenant agrees. That same doctrine was also upheld by the court and expressed by the court in McGuire v. Haddad.
I have a question. What do you say in response to your brother's argument that this does not rise to the level of a 93A violation?
Well, I mean, clearly the Attorney General would disagree with you, and we have cited to a host of decisions where both the SJC and the appeals court has concluded that the Attorney General's regulations, here they were specifically delegated responsibility for interpreting Chapter 93A with respect specifically to the tenancy relationships in manufactured home parks. And the courts have consistently said that those regulations carry the full force of law, and even expressed a preference for a decision by courts for violations of Chapter 93A, and the Attorney General's regulations explicitly provide that both of the actions by the landlords that are challenged here explicitly states that they shall be unfair. They are considered to be unfair and deceptive practices. But the conduct of the landlords in this case clearly speak to that. There's no dispute that the full cost, they recovered the full cost to them of complying with the Department of Environmental Protection Administrative Consent Order by way of the purchase.
I'm going to stop you. Your time's up. Justice Grant, did he answer? Did you get your question answered?
Yes.
Okay. I think we'll have to stop you there. We understand the arguments on both sides. Very tough case. I get the message that we're now streaming live.
Yep.
It was
Okay.
well.
Okay. Thank you for your patience, and we are on the record.
Thank you. Calling the next case, it's Victor Creatini versus Mark McHugh, 19P1159. Counsel for the appellant.
Good morning or good afternoon, Your Honors. My name is Helen Litzis, and I have the privilege of representing the plaintiff in this matter, Victor Creatini. We are before this court asking the court to reverse the trial court's decision granting summary judgment to the defendant landlord, in this case, Mark McHugh. The reasons we are seeking reversal of the trial court summary judgment decision is threefold. First, the trial court erroneously interpreted the reasonable foreseeability standard in Massachusetts to be a more specific and exacting requirement than what the law allows. Number two, the trial court misapplied the Jupin versus Kask decision by the Supreme Judicial Court. Number three, the trial court failed to properly consider the public policy implications of imposing a duty upon a landlord in these circumstances and neglecting to address the public safety and public health hazards that are at play in a circumstance such as this case.
Ms. Litzis, before you get too far into the merits, can I ask you a question about the procedure of the case?
Of course, Your Honor.
You seem to concede in your reply brief that both notices of appeal are premature and that there has not yet been a final judgment in the Superior Court. Is that correct?
That's correct, Your Honor. Under Rule 41A and the case law, there has been no final judgment rendered because the stipulation of dismissal issued in this case was not signed by all the parties who appeared in the action. I was unable to find any particular decisions except the corporate decision, the Mass Appellate Division case cited in my case that interpreted that requirement. But it is a guiding demonstration of how the law should be applied, and we believe the law should be applied in the similar circumstances here.
Well, your argument in part, as I understand it, is that we should exercise our discretion to meet the merits or to reach the merits based on UBS Financial versus Liability. That case stands for that proposition in the limited circumstances where a premature notice of appeal has been cured by a final judgment. But in this case, there's been no final judgment, so I'm having difficulty understanding how the case is properly before us, or even if we have discretion to reach the merits.
Well, there have been other cases that I've cited in my brief, Your Honor, where the appeals court and the SJC have heard premature appeals. The matter of care and protection summons case was cited, as well as the Paquette versus Department of Environmental Protection. Those cases also talk about this court exercising its discretion and recognizing the pragmatic approach to addressing issues on appeal where there has been a premature filing of a notice of appeal, and the interest in the administration of justice to recognize that there's a tendency for the court to address issues on the merits rather than the technicalities. And it would be inefficient for the court to not address the merits of this case when when the parties have already briefed the issues. We have a novel issue of law, I believe, in Massachusetts on this issue regarding the liability and the duty of care for the landlord in circumstances such as this. All of the case law seems to suggest to myself that the merits and the fact that what we have here is a novel issue of law requires this court to address it. And it would just be futile for or inefficient to go back, have the final judgment rendered, and then come right back before the court and have the same issues before you. And beyond that, there's been no prejudice argued by the defendants in this case for addressing the issues that we see here on appeal. And I think that is particularly notable.
Let me ask you one follow-up question, then I'll let you get on to the merits. Your argument with respect to the second notice of appeal is that since the stipulation of dismissal was not signed by Mr. MCHUGH, it's ineffective. But at that point in time, as I understand it, the second amended complaint didn't even include Mr. MCHUGH. He was no longer a party. So my question is, does the stipulation of dismissal need to be signed by Mr. MCHUGH in that circumstance?
Yes, it does, Your Honor. I believe that the defendant's arguments are that that where the amended complaint did not include Mr. MCHUGH, there should be there's no standing for the appeal in this matter. But what the defendant cites are all motion to dismiss cases. In his brief, he doesn't identify any cases where a motion for summary judgment was rendered, and there was a requirement in those types of cases for the defendant, or excuse me, the plaintiff to replead the presence of the defendant who was issued or discharged on summary judgment. There are concerns about whether if I was required to, in a circumstance such as this, to replead in the amended complaint, Mr. MCHUGH, there was a possibility I would face sanctions for bringing forth an action such as this. And if you take a look at the examples cited by the defendant, none of them address a motion for summary judgment scenario. And I've referenced other decisions from other jurisdictions, which I think are quite illustrative of the issues that are reflective in our play it here. For the plaintiff to—
I think I've taken up probably too much of your time on procedure. You can advance to the merits.
Oh, thank you, Your Honor. I hope I've answered your question.
You have, thank you.
Going to the merits of this case, the ultimate question that was faced by the trial court and is faced by the justices here today is whether Mr. Creatini was entitled to protection from the defendant in this case, the landlord, Mr. MCHUGH. And the answer to that question is an unequivocal yes. He deserved protections against the conduct of the defendant, Mr. MCHUGH, in the circumstances that we have here. The case law in Massachusetts is highly supportive of that conclusion and was erroneously overlooked by the trial court. I would start first with—
Do I understand correctly, counsel, that there's been no Massachusetts case that it would extend a duty of care to a property owner for damages caused by a tenant's dog? So we would be making new law in this case if we were to so hold, correct?
That's correct, Your Honor. The most recent case addressing issues that have similarity to the case here is Nutt v. Florio, which the appeals court decided years ago, which recognized or held the landlord liable for injury to the tenant in that particular case. And the incident occurred on the premises.
But you would agree that case, excuse me for interrupting, that case dealt not so much with the question of whether a duty was owed, but whether there was a breach of the duty to the tenant.
That's correct, Your Honor. And underlying that case is the duty not of a landlord to a tenant, but the duty of a landowner, which I think, or a property owner, which is particularly key and important in recognizing that application, because that guiding principle has application in the circumstances of this case, and it extends long before Nutt v. Florio. It extends to decisions by the SJC and the appeals court and other decisions where a landlord is responsible for a passerby or a third party's or injury to a third party. What we have, for example, in the Chalfin decision, the landlord was held responsible for an injury that occurred an injury that occurred to a babysitter where a fire occurred on the premises. In that case, the court did not limit the liability of the the landlord-tenant relationship. What was recognized was the relationship of the landowner and that liability or that duty extending to third parties. And that has been the recognition in a number of other cases prior to Jupin. For example, Ross versus Brightman, which I cite in my brief. And then we take ourselves back up to Jupin versus Cask, and we ask ourselves if instead of the circumstances here where we have a dog as a dangerous instrumentality, what if Mr. Creatini was injured by Mr. MCHUGH's tenant by a shooting, by a gun that is stored on the property? Would that court impose a duty on Mr. MCHUGH? And the answer unequivocally is yes, because Jupin versus Cask tells us that where there's where the danger is reasonably foreseeable to a third party, what you have in those circumstances is a duty that is imposed upon the landowner. In Jupin versus Cask, there was guns stored on the property of a property owner. The property owner's son, who was not living on the premises, came from another location, obtained the gun, then on a foot chase, located off the property, shot a police officer. And in those circumstances, the court, the SJC, held that a duty was imposed upon the property owner in those circumstances. The defendant wants this court to believe that Jupin versus Cask is not applicable in the circumstances of this case, but that is simply not true. It has direct application for this case because of the diverse factual scenarios that Jupin has been implied in other cases. If you look at the history of how Jupin has been applied since its decision—
May I interrupt, please? May I ask a question? So on your using, spreading out Jupin a little bit here. Suppose Mr. Mills legally owned a gun in his premises, and he used it illegally to shoot somebody. Is the landlord responsible to the victim of being shot?
Where's the gun? May I ask the question? Where is the gun?
It's stored in Mr. Mills's apartment, like the dog.
I think in that situation, the gun in those circumstances when the shooting occurs, is the gun removed from the apartment?
Yes, unless he goes into the front yard and starts shooting at bicyclers riding by.
I think it would be difficult in that circumstances to apply Jupin because you don't have the availability of the gun in a common area or in a common setting like you did in Jupin. In Jupin, the guns were located in the basement in a common area. In our situation with Mr. Mills, the dog, as has been undisputed by the record, was out in the common area on the property and was unleashed, and it was not enclosed in a fence. And Mr. MCHUGH had awareness and knowledge of that. So I think there are distinctions in your factual scenario where I don't believe Jupin would necessarily apply. I think it would depend again on more of the factual circumstances as to what the landlord knew about Mr. Mills' use of the gun and how the gun was stored and how Mr. Mills managed the gun, if the gun was stored or easily accessible on the property in the front yard where perhaps a child would be in a situation to obtain that, then I think you have liability in that circumstance.
I see your time is running out. Let me interject one more question. Is there anything in the record which supports the fact that the dog had vicious tendencies other than the fact that the dog was described as a pit bull terrier?
Yes, there's evidence that obviously that the dog was a pit bull, which the SJC has already recognized in its decision Commonwealth for Santiago is a vicious and aggressive type breed of animal. But also there's evidence in the record that the neighbors would hear, and Mr. MCHUGH acknowledged that he would hear the dog barking, and that the dog would, and there was evidence in the record where just approximately a month before Mr. Creatini's incident with the dog, that dog the same dog of Mr. Mills left the premises of Mr. McHugh's property, crossed the street, and then attacked Mr. Creatini's dog. And there's no evidence to dispute that incident. So I would argue, Your Honor, that the record supports a finding of negligence upon Mr. McHugh, and a recognition by this court that a duty is owed to Mr. Creatini, and the case law supports imposing that duty upon the landlord in these circumstances.
So it seems to me that it's not that far-fetched as to, I agree with you here. It's not that far-fetched to think that a pit bull in the front yard of a house might attack a passing dog. That happened next door to me. But so isn't the question beyond that though? Isn't there a question of whether, as a matter of public policy, a landlord should be responsible for everything that a pit bull on the premises might do?
No, Your Honor, respectfully, I disagree. I think the question that the case law crafts is it reasonably foreseeable that the danger or the event that occurred to Mr. Creatini would occur? And the answer to that question is yes. And we have examples where other courts and other jurisdictions have recognized and answered that question in similar situations. The Hammond versus Moore decision, for example, the dog left the premises of the landlord and attacked another individual who happened to be on a tandem bicycle. There's the additional example.
I started by agreeing with you about foreseeability, but and you started by saying that we have to look at what the public policy is here.
That's correct.
And so, isn't the public policy you're asking for that a landlord is responsible for anything that a pit bull might do, that a tenant's pit bull might do?
I don't think that, I'm not saying that, Your Honor. I'm saying that there is, the public policy recognizes that there's a duty of care that a landlord owes in circumstances such as this case because of the public hazard and grave danger that pit bulls recognize. The Massachusetts case law has already recognized that dogs pose a significant danger by recognizing in a strict liability for owners and keepers where a dog bite incident occurs. So there's already a public policy recognition reflected in that legislative enactment that dogs pose a grave danger. I think that, coupled with the SJC's recognition of the grave danger pit bulls specifically pose, recognizes that there is a duty of care that should be imposed upon a landlord in a circumstance such as this, where there is a grave risk to a third party.
Let me see. We are at time. Do the other justices have questions? No. Okay, I think we'll stop it at that. We understand your argument. Thank you very much.
Thank you, Your Honor.
And so, Attorney Gismond?
Yes, that's correct, Your Honor. All right, good afternoon. I'd like to address a couple of things that were addressed by Ms. Litzis. First, one is she had indicated that the neighbor had, there was evidence in the record that the neighbor heard the dog barking or that there were issues with the dog. The record does not reflect that at all. If you just look at Record Appendix 1, page 118, that's the summary judgment where that was represented, and Mr. McHugh's response to that is there, and it cites to the record, and there is absolutely no evidence of that. There's also no evidence in light of the questions that were asked of Attorney Litzis.
Well, can I ask you to clarify? Is there no evidence, or is it disputed?
There's no evidence.
Okay.
What the record reflects was that the witness, the neighbor, heard the dog bark right before the incident happened. There was no history of barking at this property. The way the record was represented was that there was a history of this dog barking at the property and causing issues, and there's nothing in the record to actually reflect that from either the neighbors or Mr. McHugh. Mr. McHugh also had no knowledge in this particular case, so the record doesn't indicate anywhere that Mr. McHugh knew that this dog had any sort of vicious propensities. And I'm going to get into that a little bit later. But With regard to the timeliness of the appeal that was mentioned earlier, I'm comfortable just relying on what was submitted on the papers, but if the justices have any questions, I'll be glad to field those.
I do have a question. Doesn't Ms. Litzis have a good point that if we simply dismiss the appeal for lack of jurisdiction, isn't it likely you'd be back here in 6 months?
It's possible that would be back here in 6 months. I mean, there is a case. It's Smith versus Williams, 81 Mass Appellate Court, 1109. It's an unpublished decision, and in that case, it's cited in my brief. It says that summary judgment disposing of fewer than all counts is not a final judgment. But as you pointed out, Your Honor, the moment that a stipulation of dismissal was filed between Mr. Creatini and Mr. Mills, and there were no counts left, that summary judgment essentially became final.
Is there any authority for that other than you telling us that?
Based just Smith versus Williams, Your Honor. That's it. That's the closest case that I could find on that proposition.
Let me ask it a slightly different way. Would you agree that it's in the interests of judicial economy for us to reach the merits?
Yes.
All right. Are you asking us to reach the merits?
I'd like to address the waiver issue. I'd like to address the waiver issue just briefly.
All right.
With regard to the waiver issue, there is a case that addresses this particular situation. It's actually a 1980 case. It's National Construction Company versus National Grange Mutual Insurance Company. And in that case, they specifically said, again, it's a 1980 case, so it predates this case, any matters which are not restated in an amended complaint are deemed waived. The case actually also provides a specific example of what you do to make sure you don't waive counts asserted in the original complaint. And in that case, the court had indicated that all you need to do is reference that, that prior complaint or incorporate it by reference in the amended complaint, and that's not what happened here. So essentially, the plaintiff did waive her claims against the defendant. But sort of getting to the merits of the case, even if the plaintiff did not waive his counts against MCHUGH, MCHUGH still can't be found liable in this case. One is because it's just what happened wasn't foreseeable. I think the case law that I cited plenty of case law in this in my brief, but I'd like to read one portion of it that I think is really applicable here. It says, for liability to be imposed, the evidence must show that the defendant was chargeable with such knowledge that it should reasonably have foreseen or anticipated the type of risk that occurred. That's basically what the case says. And this is, I mean, the odds of this incident happening again is, I think that you'd have a better chance of winning the lottery. I mean, what you have in this case is you have Mr. Creatini riding a bike down a hill with a dog tethered to him. You have the owner of the dog's roommate has the dog outside. The dog runs towards the other dog. The dogs start to fight. And then Mr. Creatini falls off his bike while he was trying to help his dog.
But isn't the foreseeability question broader than that? It's not, is this particular, the nature of this injury and exactly what happened foreseeable? Isn't the question whether or not injury might occur as a result of a pit bull terrier running free from their property and attacking someone or something outside the property?
I think that based on the case law, I mean, I think you need to look at the facts of each particular case. In this particular case, he didn't get injured because the pit bull ran off of his property. He actually, based on the complaint and based on the record, he got injured because he was getting off of his bike to help his dog. I think that you just sort of need to look at all the facts when you're determining the issue of foreseeability.
See, that argument, though, that's going to more of a jury question. I mean, you'd be, after summary judgment, you'd be free to argue to the jury that this is crazy, this never happens. But, you know, aren't we looking at the question of whether, as a matter of public policy, they should be able to at least go to a jury?
Well, if we're getting to the issue of public policy, I mean, I don't think that it's good public policy to hold a landlord responsible for what somebody else does with regard to their property. The pit bull in this particular case was not the landlord's property. I don't think that that's good public policy. I mean, where does it end? Where does that end? I mean, if so the dog was on the yard, what if the dog was on the sidewalk? What if they took the pit bull and they walked it down the street, up the street? Where does the landlord's liability end? I just don't think that that's good public policy at all. And one of the cases that I'd like to address in this case is Nutt versus Florio, and Your Honors addressed this earlier, but in Nutt versus Florio, that case was decided based on the fact that the injured party was a tenant of the landlord. So the landlord had a duty to that tenant. The court made it clear in that decision that that's why the case was decided that way. And that does not exist in this case. Mr. Creatini did not know who Mr. MCHUGH was, and Mr. MCHUGH did not know who Mr. Creatini was. There was no duty between them. Mr. MCHUGH had no duty.
If we separate out the duty issue from the foreseeability issue, if Mr. Creatini had, say, been invited to your client's property by a tenant for a barbecue, and he rode his bike onto the property, and then the dog the dog was on the leash the same way, and it all happened on Mr. MCHUGH's property, are you conceding that there would be liability in that situation?
No, Your Honor, and I really haven't sort of analyzed the case from that perspective. But based on the cases that I've read, again, I think I would kind of go back to what I said before. This dog is a piece of property, and and it's not Mr. MCHUGH's property. The property belongs to Mr. Mills. And I would say that in that situation, there would be no liability. Your Honors, I did address.
Can I follow up on that?
Yes.
So I mean, it seems to me that the plaintiff is arguing your client's responsible for everything the dog might do. It seems like you're arguing is your client's not responsible for anything the dog would do.
Well, I mean, I think in this case, my argument is that my client's not responsible for this particular incident. I mean, I really haven't analyzed it from the perspective that was just provided to me, but I kind of responded from my gut when that question was asked.
That's fine. And so what if there's a third floor tenant too, right?
Yes.
What if Mr. Mills's dog had bitten the third floor tenant?
Well, Nutt versus Florio comes in that play in that situation.
So that would not be good for you.
Well, actually, I see that I'm getting close to running out of time, and a lot of my argument I'm not going to be able to advance. So I want to kind of skip to something that actually addresses that directly.
Okay.
So if you look at the Superior Court decision, the Superior Court decision cites Chapter Mass General Laws, Chapter 140. Mass General Laws, Chapter 140 has a section. It's called Section 157. This Mass General Laws, Chapter 140, Section 157 was amended on October 31st, 2012, which means it was amended before this incident happened, but after the Nutt versus Florio decision. And in that case, that particular statute is entitled this: nuisance or dangerous dog, order for remedial action, appeal, violation of order. That particular statute says this: any person may file a complaint in writing to the hearing authority that a dog owned or kept in the city or town is a nuisance, and this is important, or dangerous dog, provided, however, that no dog shall be deemed dangerous solely based on growling or barking, or solely growling and barking, based upon the breed of the dog. So that's number two, based upon the breed of the dog, or, and then it goes into another section. So the important language in that particular statute is that the legislature, after the Nutt versus Florio decision, and before this incident happened, decided that a government municipality cannot determine whether a dog is dangerous solely based on the breed of the dog. And that's exactly what Mr. Creatini wants this court to do. The argument in the brief completely focuses around that this dog is a pit bull, that this dog is dangerous, that Mr. MCHUGH had some kind of heightened duty. But the legislature has spoken and they have indicated that you cannot consider the breed of a dog in determining whether or not a dog is dangerous. So in light of that statute in 2012, and if you look at Nutt versus Florio, which goes back to 2009, in theory, Nutt is no longer good law. And if you look at the statute, the history of the statute, when Nutt versus Florio was decided, there was language in that statute that indicated or that suggested that you can consider the dog's breed. Prior to October 31st, 2012, that statute said that you can consider the dog's vicious disposition. So I guess in theory, if you look at the decision in Nutt versus Florio, the court kind of decided in that case that a pit bull had a vicious disposition, so they determined that the dog was dangerous. But I would say at this point going forward, with regard to this dog biting the tenant that Your Honor gave an example of, I would say that this statute essentially makes Nutt versus Florio no longer good law. So this also goes to the public policy argument that Attorney Litzis is advancing. So if this court was to find that public policy requires MCHUGH to secure someone else's property that he doesn't own because of the dog's breed, which is she wants this court to do, it would directly conflict with what the legislature said in 2012 when it changed Mass General Laws, Chapter 140, Section 157. In fact,
is there any question that the dog is a pit bull terrier?
So that's a good question, Your Honor. The record actually reflects that the dog is either a pit bull mix or a full pit bull. There is nothing in the record that specifically says that this dog is a pit bull. It says it's either a pit bull mix or a pit bull. And the reference, if you'd like that, is it's Record Appendix 1, page 119.
But Judge Feely, in his decision, made the assumption or operated on the assumption that it was in fact a pit bull, correct?
I think he did that because he considered the facts in the light most favorable to the non-moving party, so yes. So I guess in conclusion at this point that since the legislature has spoken in this particular case, and it's clear what the legislature's policy is, it would be wholly inappropriate in this case to find that Mr. MCHUGH had some kind of duty to contain this dog in this case. So this court should uphold the lower court's decision.
Okay. Thank you both for your arguments. Very interesting case. Love this. Attorney Martland, can we hear you?
Yes.
Okay, good.
Excellent. And we are live and on the record.
Great. Good afternoon and welcome to the last argument for today's oral argument session in the appeals court on November 6, 2020. As you know, the argument is being conducted on Zoom and simultaneously live streamed on YouTube. Once we get going, the session clerk will post a countdown clock and the other parties will be muted. Both parties have 15 minutes. I understand that the appellees are splitting their time 50-50, 7.5 minutes each. Thank you. And I apologize for us being a little late here. We had some technical difficulties earlier, and hopefully that won't occur again. But if it does, we might have to put you in the waiting room or start again, but hopefully that won't happen. So as always, we've read your briefs. We're familiar with the case. And although you're free to use all 15 minutes, we won't hold it against you if you finish early. So with that, I'll call the case. It's Foley versus Safety Insurance Company and another, 20P205. Attorney Foley for Appellant Foley.
Good morning. May it please the court. I'm Kevin Foley, representing the plaintiff appellant, Lauren K. Foley. And I'm sure that the court does not see this type of case very often. So I appreciate the granting of the appeal and the opportunity for a hearing this morning. Good morning also to Attorney Wilson, Attorney Martland. I was a little worried, Your Honor, when I first, because I got kicked off a little while ago. I'm not the most versed person with technology, so I appreciate the opportunity to speak with you now. The two issues that I have before the court this morning are really fairly intertwined and related. The plaintiff appellant did not get a fair hearing, and the resulting decision, which was affirmed by the Superior Court, is not supported by substantial evidence. And of course, as the court knows, under Chapter 30A, everyone is entitled to a fair hearing before a fair, neutral arbiter of the facts. And in this particular case, the hearing officer made a pronouncement during the hearing where he said that he essentially hears the same story by appellants of surcharges all day long. And that statement alone, I would say to the court, at least leads to an appearance of impropriety or bias against appellants, and that they are not going to get a fair hearing, and that the result was going to be somehow preordained, rather than
Mr. Foley, was that issue raised below in any way?
Yes, I brought that up at the Superior Court, Your Honor. The Superior Court, to my chagrin, really didn't take up the issue or make a decision with regard to the fair hearing part of this, but certainly the transcripts of that hearing were before the court at the time that we had the motion to reverse hearing last December.
I take it that it was never raised with the hearing officer and there was never a motion filed for recusal.
No, I did not make a motion for recusal at that stage of the game. Perhaps I should have, because, really his conduct during the hearing, quite frankly, didn't alleviate, Your Honor, or dispel any notion of bias. He, as I mentioned in the brief, he interrupted the appellant. He questioned her veracity or her consistency while she was trying to respond to questions to him. He actually argued with her at one point, and he didn't listen to any of her testimony, really, or didn't credit any of her testimony or any of the documents that she submitted. And at one point, I just reminded him that she was really the only person with firsthand knowledge who was testifying live before the hearing. And at that point, he threatened to not find her credible. And so for all those things, I don't think that she got a fair hearing. Of course, if he didn't find her credible and didn't believe her testimony, that doesn't make the opposite true under Massachusetts law. I think that's pretty well established. And so,
but you understand, I'm sure, Mr. Foley, that one of the difficulties you face is that in hearings such as these, an appellate panel relies on the credibility determinations of the hearing officer. And we give some deference to those determinations.
That's correct, Your Honor. And I'm not asking you, I don't think that this court or the Superior Court would be in any position to second guess credibility. That's just not what I'm asking. All I'm suggesting is that she didn't get a fair hearing. He had prejudged the facts. He sits there in the hearing room next to safety insurance all day long, calling the hearings, and then completely ignores, as I'll get into in just a moment, the direct testimony, maybe most importantly, the direct evidence that the 19-year-old driver who was driving that pickup truck with the plow on it was driving at excessive rate of speed at the time of the accident. The hearing officer made no findings about that whatsoever, even though he saw that in the Foley testimony, he saw it in the Castellano's affidavit, he saw that in the appeal to the surcharge, he saw that in the Foley accident report, and quite frankly, in the notes from the insurance company, that he was speeding.
Counsel, on your hearsay argument, are you arguing that the police report shouldn't have come in, or just that the hearing officer should not have credited it when faced with in-person testimony?
Well, I'm not suggesting, Your Honor, that it shouldn't have come in. Hearsay is admissible under 30A hearings, and I'm not asking this court to second guess the credibility assessment. What I'm saying is that and I'm not saying the police reports don't amount to substantial or credible evidence. But I think that happens on a case-by-case basis. I'd ask the court to take a look at the dissent of Justice Lynch in the Embers of Salisbury case. He sets forth some standards or some questions about how do we judge hearsay and whether or not it rises to the level of substantial evidence. And he puts down some factors in there. You know, was it sworn testimony? Was it corroborated? Was it disputed by direct evidence or direct testimony by a witness who was a disinterested witness? And I think you have all those things present here. You have a police report that is not corroborated anyway. The police officer wasn't at the scene. He never talked to the appellant, never talked to the direct witness, and made some conclusory remarks. I think you'll hear safety and you'll hear my brother from the Attorney General's office saying it's corroborated by the other documents in the record. But it's clear to me that the critical findings that the appellant did not proceed with caution into the intersection and obstructed traffic, those come directly from the police report. I mean, the hearing officer relied solely on the police report, and Maresme says that, you know, mere uncorroborated hearsay does not amount to substantial evidence.
Can I stop you? Can I ask a question? Because it is on Maresme. Maresme applies a 30A substantial evidence review, but in the subsequent case of Narcessian, which is 46 Mass App 766, it seems to say that the standard is whether there's no basis in fact whatsoever, as opposed to substantial evidence. How do we reconcile those two?
Well, you know, I think that I think best to look at, I think that the Goodridge decision basically says, you know, what amounts to substantial and credible evidence? Does it have an indicia of reliability? Is it probative? Is it corroborated? Is it reliable? And really, police reports can be all those things.
I don't think that's responsive to my question, though, because the Narcessian, it points out that in this statute, it says the decision of the Superior Court is final, yet it permitted appeals to go forward. And it says I think it basically says we focus on questions of law and we don't re-examine the weight of the evidence unless there's no basis in fact. I mean, and if that's a governing law, I mean, I don't think you can argue there's no basis in fact for this.
Well, I'm not saying there's no basis in fact. I'm just saying that the facts as found by the examiner, he ignored a critical finding in that the other driver was driving at an excessive speed. You know, this is a situation, Your Honor, where the appellant, it's uncontested. She was in the middle of that intersection when the other driver came along. Castellanos, who was the eyewitness who has no axe to grind and not related in any way to the appellant, said that he was driving well in excess of the speed limit and hit the back of her car. The police report does not say that Foley, you know, all of a sudden pulled out in front of this driver, blocking his way, and he had no choice but to hit her or run into other traffic. That isn't what the police report says. The driver, the 19-year-old driver, told the officer, "Oh, I saw her creeping out into the intersection." Well, if that's the case, if that's the situation, then why didn't he apply his brakes? Why aren't there any skid marks? And why does he hit her in the rear back panel of the car?
I have some questions about the credibility of Ms. Foley as far as the evidence that was before the hearing officer. My understanding is that at one point she testified that when she first saw the truck, it was 40 feet away, and then but she had said in her appeal that it was 200 feet away, and in addition, she said in her own accident report that she had no passenger with her, but then she testified at the hearing, "My boyfriend was with me." How do you, couldn't the hearing officer consider those discrepancies in deciding whether to credit the in-person testimony of Ms. Foley?
Yeah, the boyfriend, let me start with the boyfriend. She did not say the boyfriend was in the car, Your Honor. You'll see nothing about that in the transcript. He arrived at the accident scene after the accident took place. He's the son of a former state trooper, well known in North Andover. The police officer recognized him and he asked him, "Do you need to speak with Laura?" And the officer said, "No, I don't. It's clear to me that this other drivers at fault. That's what was said at the scene. The officer never talked to Foley. With regard to the distances, I think it's clear from reading that transcript that she was confused by that question. She wasn't sure what they were asking her. And quite frankly, I think that when she filled out that accident report and those forms for the appeal, when it asked her about the distances, she put 200 feet on one and 150 feet on another. But it doesn't change the fact that she was in the middle of that intersection when he came down that road at a high rate of speed. And had he not been driving at a high rate of speed, she would have lawfully proceeded through that intersection without being hit. And so for the officer to ignore that speeding, and by the way, I must say this, the Superior Court Judge Liu, he heard virtually some of the same argument I'm making today. However, in his denial of the motion to reverse, he says, and the driver was driving slightly above the speed limit. I'm not sure where he got that from, because there's nothing in the hearing officer's findings. There's nothing in the decision that the other driver was driving above the speed limit. He solely focused on that police report, which has conclusions in it that she was inattentive, she didn't proceed with caution, and that she obstructed his traffic. And so my argument is, with an unsubstantiated, uncorroborated police report, it's mere totem pole hearsay in the face of, quite frankly, direct testimony, documentary evidence, everything that Lauren Foley said in her accident report she files with the North Andover Police Department at the time of the accident, her surcharge appeal, her testimony at the hearing before the hearing officer, and the affidavit of the eyewitness is all consistent, very consistent. And so, but it was completely ignored. No findings about speeding whatsoever. So, in essence, what I'm saying is the police report doesn't amount to substantial evidence, because, it isn't like Embers of Salisbury, where it was a sworn statement. Even though the hearing officer, if you read the transcript, if this court reads the transcript, in many occasions when he was arguing with the appellant, he said, this police officer, he swore this report is a sworn report. He signed it on is a sworn report. Look at the police report. It's not sworn. How can a hearing officer, he jumped in and became an advocate for safety insurance. He wasn't there as a neutral, unbiased hearing officer, as he should be. And I would venture to say that if the agency did a quality control on his cases, I bet he never fines for appellants of surcharge appeals. And I suspect that many of those surcharge appellants don't have fathers who are attorneys who can pursue this thing in Superior Court, because quite frankly, there's great obstacles to appealing one of these surcharge appeals. And if she was hurt or killed, she would be foreclosed from pursuing any sort of claim, because she would have been hit with the surcharge appeal. So I'm sure when the stakes are higher like that, if there was a serious injury or something like that, people might get some attorney to take it. But in the normal course of things, this is an expensive proposition for drivers who probably give up after the hearing, because they go into this hearing officer who sits there with safety all day long, never fines for appellants, and that's the end of it. And, not all these cases should make it up to the appeals court. There's a reason why this one did. It's not supported by substantial evidence. And quite frankly, nothing that I've said or diminishes the Goodrich decision, which says when you have two versions of events, one of them hearsay and one of them not hearsay, hearsay gets trumped by the direct evidence. And the hearing officer's reliance on the police report, while ignoring direct testimony, shows his bias, and his decision is not supported by substantial evidence. And it's for all those reasons that I'd ask this court to, vacate the judgment or reverse the judgment of the Superior Court and remand this thing back for a new hearing before a new hearing officer with new appeal rights. The first time I saw that police report was on the day of the hearing. It hadn't been sent to us. I didn't know it existed. I didn't know that safety had relied on it to impose the surcharge upon the appellant. And quite frankly, it had some untruths in it. The officer never talked to the appellant at the scene, and for whatever reason, never contacted Julie Castellanos, whose cell phone number was on the police report. I did see in the notes from the insurance company, they
I'm sorry,
attempted to
Attorney
contact
Foley.
her, but they never did.
I'm sorry, I'm gonna have to interrupt you. Your time's expired, and we've got the record, so we can review that. So thank you
very much, Your Honor. I'm just going to hang on and listen.
Of course, yeah. Attorney Martland, you're going first.
Yes, Your Honor. Thank you. Good afternoon. May it please the court. Douglas Martland, Assistant Attorney General for the board. I'd like to address 3 quick points. The first is that Foley has the wrong standard of review. Under 113P in Nassarian, this court's review is quite narrow. It's limited to determining whether the Superior Court committed an error of law, and it does not include a reevaluation of the factual evidence unless there is no evidence to support the board's determination. As Foley has already conceded today, there is evidence to support the board's determination.
You also cite Merisme in your brief. I mean, does Narcissian supersede Merisme or?
That's correct, Your Honor. Narcissian supersedes it, and makes clear that the review here is quite limited to an error of law, and not a reevaluation of whether or not there was substantial evidence, or a reevaluation of the credibility determination made by the hearing officer, which, as this court has already noted, we give great deference to the hearing officer's determination. The second point, Your Honor, is that it's quite clear here that the hearing officer permissibly relied on the hearsay evidence, which is the police report, as part of the totality of the evidence for upholding the surcharge. Police reports, which are based on an officer's official observations, are exactly the type of document relied upon in traffic accidents and surcharge proceedings. It's corroborated here by numerous pieces of evidence. Ms. Foley's appeal form, safety surcharge materials, the affidavit from the witness, and Foley's own testimony. What there are discrepancies between Foley's statements at the hearing and the police report. And the hearing officer here made a determination based on the evidence that Ms. Foley's statements at the hearing just were not consistent and were not credible. And again, the court gives deference. Finally, Your Honor, there's no evidence here that the hearing officer was biased simply because he didn't agree with Foley's evidence or find her credible. We commit these type of determinations to the hearing officer, and the hearing officer here probed all of the witness testimony, listened attentively, engaged with the witness, and demonstrated a strong command of the record during the hearing. That he used a frank summation of the problem the plaintiff is facing in overcoming the presumption is not a reason to determine he was biased. If there are no further questions, I'd ask the court to affirm the Superior Court's determination.
What about his comment that we hear this all the time? Isn't he kind of giving short shrift to the witness's testimony?
No, Your Honor. What it is a frank statement of the problem that the plaintiff is facing in overcoming the presumption of fault. She has the burden of proof at the hearing, and when you look closely at the hearing officer's exchange with Ms. Foley, what he is saying is that you have to do more than just say that I was hit by the other car that was going fast. That's a fair summation of his view that her evidence did not satisfy her burden of overcoming the presumption of fault. If there are no further questions, I'd ask the court to affirm the board's determination.
Seeing none, we'll hear from Attorney Wilson.
Good afternoon, panel. May it please the court, I agree pretty much wholeheartedly with what Attorney Martland has said. One thing that I would like to point out from Judge Liu in his clerk's notice from December 9th, 2019, which is in the assembled record appendix, he finds that based solely on the petitioner's testimony, the hearing officer could have determined that Foley failed to use reasonable care in entering the intersection while another vehicle had the right of way. Now, that's not to say that the police report shouldn't have been considered, or the police report is hearsay that doesn't rise to substantial evidence. But in this case, Judge Liu made it clear that even if you took that out of the equation, Ms. Foley's own testimony met the standard of fault that the hearing officer was reviewing on the date of hearing. As stated, we believe that the hearing officer, and I think it's clear both in the transcript and just the paperwork that he looked at, that he was looking at the totality of circumstances. In fact, if you look at the transcript, he takes time out 2 different times during the hearing to read documents that weren't provided to him until the time of hearing, both the affidavit as well as, I believe, the operator's report of Ms. Foley. He asks questions of Ms. Foley when he's unsure of exactly what she's saying, and he gives her ample opportunity to rectify any inconsistencies that he's found within the record. I think to say that that is prejudging or biased is just incorrect in this case. Unfortunately for Ms. Foley, the decision did not go her way. However, the rule is not that if you dislike the decision, that means that it's not based on substantial evidence. And in this particular case, as I'm sure you've seen in the record, there's more than enough substantial evidence for the hearing officer to have found the way he did. For that reason, we would ask that the Superior Court's findings be upheld. And if you have any questions, I'm happy to answer. Otherwise, I'll rest on those grounds.
How did Judge Liu find that the other driver was just slightly above the speed limit?
As far as Judge Liu's finding on slightly above the speed limit, I believe Ms. Foley stated that he was traveling downhill and speeding. As far as his particular verbiage, I don't know that that appears in the record, but it's clear that Ms. Foley is where the basis for him going above the speed limit would have come from.
All right. Any other questions? Seeing none, I guess we can take you both on your briefs, and thank you all for your arguments. That will conclude today's oral argument session, and we'll take the case under advisement and be in recess. Have a good afternoon.